Good morning, everyone. It's 9 o'clock. We'll go ahead and get started with today's Pennington County Planning Commission meeting. Recommendations of the Planning Commission on certain items from this agenda will be considered by the Board of Commissioners at their regular meeting on March 2nd, 2021 at 10:30 a.m. The Planning Commission utilizes speaker request forms, which are available in the commission chambers during the meeting, and so they're back on the back table. If you'll fill one of those out and get it to one of the staff members or place it over here on the corner of the table, they'll bring it up. Helps keep me organized. There should also be agendas back there in the bookcase. First item on the agenda is the roll call. Note that Deb is here from the commission and Sandy and Kathy are gone. First item on the agenda is approval of the February 8th, 2021 minutes. Are there any changes, edits, corrections to the minutes? Hearing none, seeing none, I would entertain a motion for approval of the minutes.
So move.
Second.
Motion and second. Further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Those opposed, no. Motion carries. Item number 2 is approval of the agenda. On today's agenda, we have items 3 and 4 on the consent agenda, followed by regular items 5 through 11, and our normal end of agenda items 12 through 16. Is there any changes to the agenda today?
Move to approve.
Second.
Motion and second. Further discussion? Hearing none, seeing none. All those in favor signify by saying aye.
Aye.
Aye. Those opposed, no. Motion carries. Brings us to item 3 on the consent agenda.
Good morning, Commissioners. Brittany Molitor, Planning Director. The following items have been placed on the consent agenda for action to be taken on all items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent agenda by any planning commissioner, staff member, or audience member for separate consideration. The findings of this planning commission on certain items from this agenda are recommendations to the Pennington County Board of Commissioners, who will make the final decision. Item number 3 is conditional use permit review CU 1412 for Penelope Cox to review a single-wide mobile home as a permanent residence in a suburban residential district. Staff is recommending approval of the extension of conditional use permit CU 1412 with conditions. Item number 4 is conditional use permit review CU 1927 for Marilyn and Greg Bull to review an existing single-family residence to be used as a bed and breakfast in a low-density residential district. And staff is recommending approval of the extension of conditional use permit CU 1927 with conditions.
Thank you. Are there any questions for staff on any of these items? Seeing none, is there anybody in the audience that wishes to speak on any of these items? And I forgot, is there any questions from the membership on any of these items? Hearing none and seeing none, the recommendation is for approval of today's consent agenda items 3 and 4. And one last time for the folks in the audience, these are the consent agenda items, so 3 and 4 will be taken at the same time. No one wants to speak on these items, correct? None noted. I would entertain a motion for approval of today's consent agenda.
Move to approve the consent items number 3 and number 4.
Second.
Motion and second. Is there further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Aye. Those opposed, no. Motion carries. Item 5.
Good morning, Commissioner. Chutiyama Sabbun, Planning Department. This item is conditional use permit request to allow a guest house on the subject property. The applicants are Rodney and Teresa Cassidy. Mr. Cassidy is here in the audience. The subject property is 1.09 acre zone low, low, low density residential district. It is not located within spatial flood hazard area. The access is off of River View Court. Lots contain a single-family residence. Department of Equalization shows that the residence was built in 1962. In 2017, an attached garage with breezeway was built. Building permit COBP 170588 was the proof that the attached garage was permitted with a bathroom and a storage room without living space. The space could not be used as a living quarter, nor could the on-site wastewater system increase. On-site wastewater treatment system. Resident was built in 1962, and we have a limited information during that time period. However, in the operating permit COOP 150057 shows that the tank size is 1,500 gallons. There's also another permit. Variance VA 1716 was approved to reduce the side setback. Oh, no, I'm so sorry. To reduce the side yard setback from 25 feet to 8 feet on the west side of the property line, on the west property line, to build an attached garage on the subject property. The applicant at that time stated that he could comply with the front yard setback. There are two violations on the property. COVO 200013, the storage room was converted into a living space in the attached garage without approved permit. COVO 210013, the attached garage appears to not meet the minimum front yard setback requirement of a low density residential district is 25 feet, and there's possible on-site wastewater treatment system violation. During the interdepartmental review, County Environmental Planner on-site wastewater treatment system comment that the operating permit shows 1,500 gallon tank size. However, it does not show the size of the drain field. So a decision related to the environmental concern of the proposed project cannot be made at this time. Proof or document or both is needed that indicate the size of the drain field currently connect to the septic system. The comment from County Ordinance Enforcement Officer is that the same thing, that that's a violation. And for COVO 200013, when the garage converted into the living space, so this conditional use permit request will correct this violation. In order to correct the other violation of COVO 210013, the applicant need to verify that the garage meets the requirement front yard setback. No other concerns or objections to the conditional use permit request from other department received. In On February 19, 2020, a violation case was created because the attached garage was converted into living space. Our county ordinance enforcement officer has reached out to the applicant since 2020. In January 6, 2021, the applicant applied for a conditional use permit to allow a living space in the attached garage as a guest house on the subject property.
Chutima, is this going to be continued?
Yes.
Okay.
Yep, it's gonna be continue. So there are couple concerns that the staff would like to work with the applicant to address this. And staff recommend to continue it no later than the May 10th, 2021 Planning Commission meeting.
That'd be my motion, Chair.
We do have a speaker request form
Sorry.
from the applicant. So I'd like to allow that to happen.
Okay, I'll second the motion so that we can go ahead and move forward with that.
Okay, continued, and there's a second to May 10th?
That was the motion.
Yes, sir. And the applicant can still speak, Rich?
Yes.
Yes, sir.
Motion and second, further discussion. Are there any questions for staff on this item?
Just one. When the violations that were noted in your report occurred, did the current owner own the place?
Yes.
Okay, thank you.
Further questions for staff on this? Okay. Mr. Cassidy, do you want to come up? And then when you get to the podium, please state your name into the mic.
Good morning, I'm Rod Cassidy. Thank you for your time this morning. First of all, I'd like to address the fact that when we applied for the garage permit, it was noted that it was going to have a man cave. It was not going to be storage. That is on the application. Second of all, during the time, the bathroom was noted along with a shower and the, I'm sorry, I forgot part of my paperwork. The on-site water treatment was approved for that bathroom. I have the signature of and the stamp from the county on that. Also, I don't think that a conditional use permit is needed in this situation. The garage is attached to the house. Therefore, it also has the same water, electrical, and water, or I'm sorry, water treatment, electrical, and water to it. There's no outside meters or anything. I consider it part of the house, so that room in the garage or is not a guest house as they're saying I need a permit to. It is part of the house. It's like any room in my house. I can put a bedroom, I can put a bed in my front room if I want, because it's my house. I don't believe that a special use permit is required at this point. And last thing I'll say is I only heard about these other violations with the sewer and the setback on Friday when I got a letter in the mail from the county. I did take measurements last night, and from the road, the edge of the road to the corner of my garage is 41 feet. I think that more than meets the variance that needed to be there. I checked with my road commission, and they are in agreement, and if I need to, I can get signatures, or I can bring them in and have them verify that.
Okay. Any questions for Mr. Cassidy?
Yeah, I've got one. You still would have had to have a CUP for a bed and breakfast if you were going to operate with what you want to do here.
I would, but it's not a bed and breakfast. It's just an
I'm
additional.
just saying that
Okay.
you would have had to
Sure.
even though it's attached to the house. Just wanted to clear that up.
Okay.
No big deal.
Okay.
I think that they also don't allow a bedroom in, our ordinances don't allow a bedroom, do they? We don't change what we require them to do, but we don't allow a bedroom in a garage, do we? Over a garage?
We do, but there's also a kitchen, so there's a separate living quarters in this
Correct.
garage.
I knew there was
And so
something.
to clarify some of the on-site wastewater treatment system, with a bathroom, we don't consider that a requirement for an upgrade to a septic. But when you add a bedroom, because the state administrative rules,
Right.
sizes septic systems based on the number of bedrooms, because a bedroom was added in, the garage.
Due process.
That would require, to verify that the septic is sized for the number of bedrooms total between the two structures.
You did a much better job explaining my next point. Okay, thank you. Did you understand what she was saying about why
Yeah,
there's an
partly, but
additional review?
as I've looked it up, that a 1,500-gallon septic system is a large enough size for the bedrooms of the house we have, or bedrooms in the house, which is 4. So that should be more than enough to accommodate an additional bedroom.
And I think that the concern was the size of the drain field, knowing the size of the tank.
Unfortunately, when I got the original permit, I had to come to the county to get the drain field. If you look at the original planning, somebody hand drew the drain field in. I don't know how I would rectify that short of digging it up.
Do you know the limits of it?
I do not. Again, I did ask twice that the people who drain the septic system give me an accurate measurement on the tank, but they had never gave me anything, and I don't think they can give me an accurate assessment of my drain field.
Okay,
So Chairman,
go ahead.
did you say you live here?
Yes, I do.
Okay. So it's just part of his house, you're not using it as a guest house or anything?
No, ma'am.
So Chitima, can I ask you a question? Why did you add it as a guest house when it's part of the living space? Because it has a separate kitchen?
Just 1 second.
So you just have yourself, sir?
So-
Who lives in the house? Hold on, just a sec, Chitima, just you live in the house or?
My wife and my mother-in-law live in the house too.
Okay.
Okay, so when the conditional use permit application, when we receive it in the application, it was stated that is to request to allow a guest cottage with disability. So the request is not from us, it's from the applicant. And
Okay.
it was stated in there, so I'm not sure, how's that?
I did that after, but in dealing with this and determining that this is not a guest cottage, I would withdraw that application if you would see fit to deem that this is part of the house and not a guest quarters.
Okay, sir, so you probably need to work with the planning department, and then they can bring this back as not a guest house and tell you, how you apply differently then, sir, at this point. Maybe go up there today if you have time with Ms. Chutima.
Okay,
Okay, sir.
all right.
Thank you.
So the current, just, go ahead.
I was just going to ask one more question.
Yes.
Does this application, though, because of the additional bathrooms, still take a state review? In other words, a review on the state, or is it just local? Depending on the request, I guess, that he
Sure.
makes.
So in our zoning ordinance, if it's anything besides a single-family residence that's a conventional system, it does require a state review if it's a guest house, multifamily dwelling, or anything. So once we have the
Or a
drain
bed and
field,
breakfast,
or any, yes,
so that they can have other people that aren't family members staying there and rent it out, it would take a state review.
correct. Because either way,
But
the way that we look at it, it has separate living quarters, so it'd be one of two things. It would either be a guest house or a multifamily dwelling under our
where I'm
ordinance.
headed, at that
Yes.
point, the state's going to ask what size the drain field is.
Correct.
So it's not just him, but we're in the same pickle. We can't advise them as to what you've got.
It sounds like there's,
Sorry.
oh, I'm sorry, go ahead.
No, I'm sorry. I just wanted to clear that up, that either way it went, it's not just us or him in a pickle, we're in a pickle. We can't properly advise the state so that they may review it.
Yeah. So it sounds like there's some if this, then that type things that need to happen. And right now, the motion on the floor is to continue this item to no later than May 10th. Not saying that that's how long it will be, to allow you to work with planning staff to get this resolved. Are you agreeable to that, sir?
I am.
Okay.
I only have one other request. I was fined for something and I have no idea what. And I either would like a definition of why I was fined and for what, and if I could get that fine returned, because I was working with Dwayne, and I apologize, I can't remember his last name. We actually sent a check in for the CP or the CUP. They received it. They did not cash it. We were working with him at the time. He sent me a link to pay it. That link got put in my junk mail and I couldn't find it, so we got paid late and they assessed the fine. And I would like to request that fine returned.
So I think it, sorry, Chairman.
Go ahead.
So it might not have been the CUP, it might have been the violation for, am I correct, Brittany? For the no building permit, if I'm correct.
Correct. It was it was charged double because the conditional use permit wasn't applied for before the he hasn't gotten the building permit yet because the CUP is required before the building permit, but because that was converted into living space or separate living quarters prior to getting in the CUP, that's what the additional $300 was for.
And he can come to the Board of Commissioners if he wants to plead his case, right?
Correct. So we do have an application, Jerry has an application that he can fill out to get on the agenda to be in front of the board to request that.
And so you can come back at a later time and ask for, based on your conditions and what had happened, you can come back to the Board of Commissioners and ask for the 300 back. Usually you can't build something before you have a permit.
Okay.
Yes, sir.
All right.
Further questions? Okay. Anyone else in the audience wish to speak on this item before the board votes? Hearing none, seeing none, motion on the floor is to continue CU 21-03 no later than May 10th, 2021, Planning Commission meeting to allow the applicant time to work and discuss options with the Planning Department. All those in favor signify by saying aye.
Aye.
Aye. Those opposed, no. Motion carries. Thank you,
For your
sir.
time.
Brings us to item 6.
Good morning, Commissioners. Jason Fennison, Assistant Planning Director. Agenda item number 6 is conditional use permit 21-05 to allow an accessory structure, a garage, prior to a primary structure on the subject property in a limited agriculture district. Applicant and landowner is David Spear. The agent is Fisk Land Surveying, and Janelle's in the audience if you have any questions for her today. Site location is 12760 Old Hill City Road. Approximate size of the property is 12.8 acres. The zoning ordinance lists 7 factors the Planning Commission may consider in their review of conditional use permit applications. They're on the screen. We'll read staff's responses as we go through those. Starting with number 1, the requested use is for an existing garage. It should not be detrimental or endanger the public health, safety, or general welfare of the public. Number 2, it should not substantially impair or diminish the uses, values, or enjoyment of other property in the neighborhood for purposes already permitted. Number 3, the requested use for an existing garage, therefore it should not impede the normal and orderly development and improvement of the surrounding property or uses permitted in the district. Number 4, county highway verified that the existing approaches are permitted. An address will need to be assigned and posted in accordance with Pennington County Ordinance number 20, and that is included as a condition of approval. Number 5, the existing approaches will provide ingress and egress as to minimize traffic congestion on Old Hill City Road. Number 6, the requested use is for an existing garage, so it conforms to all applicable regulations of the district in which it is located. And lastly, number 7, future land use is identified as ranchette. An existing garage is consistent with that district. If you recall, last month, the Board of Commissioners approved Layout Plan 20-45 in order to subdivide the subject property and create lots 1 and 2 of Grindstone subdivision. Approval of this conditional use permit will satisfy condition number 1 of that request. The 16 by 24 foot detached garage will be located on proposed lot 1, which is highlighted in green towards the bottom left of your screen. And with that, staff finds no significant issues with the applicant's request as it appears to be in harmony with existing lots and current land uses in the area, and recommends approval with conditions.
Thank you. Are there any questions for staff on this item? Seeing none, is there anyone in the audience that wishes to speak on this item? Noting none, staff recommends approval of conditional use permit CU 21-05 with 4 conditions. Is there a motion?
So moved.
Second.
Motion and second. Further discussion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Those opposed, no. Motion carries. Brings us to item 6.
All right,
Excuse me, item 7.
correct. Agenda item 7.
I would have gotten there sooner or later.
Minor Planned Unit Development Amendment, PU 21-02, to amend an existing planned unit development to reduce front yard setback from 25 feet to 0 feet, and to reduce side yard setbacks from 10 feet to 0 feet in order to construct a garage/maintenance building on the subject property. The applicant is Little Guys LLC. The applicant is Ben Brink. Site location is approximately 1 mile north of the Keystone city limits. Size of the subject property is 5.01 acres. As it sits today, the property does contain a single-family residence as well as a detached garage, both built in 1928 according to Department of Equalization records. The applicant has stated that he's removed that detached garage, and with that, he'll need a removal permit through our office, and that is included as a condition of approval. It does contain an on-site wastewater treatment system as well as a sign permit for a 20 by 16 double-sided sign. Access is via 2 approaches off Highway 16A. There is no special flood hazard on the area or on the property. The request was sent out for interdepartmental review specifically to the state DOT to see if there were any line of sight issues with the proposed structure, and there were no objections received. So staff finds no significant issues with the applicant's request as it appears to be in harmony with existing lots and current land uses in the area, and therefore recommends approval of minor planned unit development amendment PU 21-02 with conditions.
Thank you. Are there any questions for staff on this item?
Chair,
Sure, go ahead.
sorry.
Go ahead, Deb.
So this is a PUD, and then you have 0 setbacks on here. Is there, you don't believe at that point that anybody else is gonna build, or that's gonna cause issues later with that 0 setback, especially with the PUD, and that means multiple buildings or multiple things that can be built.
Correct. So
around
I
it,
did do a
right?
site visit of the area, and if you look on the map here, these are the property lines that we're looking to reduce the setbacks to.
Okay,
This is a photo from my site visit, so you can see the topography of the area. It doesn't appear that it'd be conducive to any further building.
how far, Jason, can I ask you, how far setback from the road is their house?
That meets the 25-foot setback for the district.
Oh, that doesn't look 25, but that's pretty crazy how close that is, but, so, you believe no one's gonna build basically in this picture, to the left of that,
No, ma'am.
based on 0 setback because of the, because it looks like there's room, if those guys built there, it looks like there's room for people to build something else there.
Right, and I can bring the applicant up. He's in the audience as well, if he may be able to answer some of these questions for you.
Well, who owns the land, does he own the land by the rock there?
To the north? I don't
Yes.
believe
Is
so.
that the north? Okay, thank you.
Further questions for staff before we bring the applicant up?
Yes. And so I don't get confused, it says that we're going to 0 setbacks, and that's the construction, a garage maintenance building on the subject property. But we also removed one. Was it removed from that location?
That's correct. Yeah, it was a smaller garage. They planned to build one larger, and that's why.
Because the older garage was what, 1928 according to our records?
Correct.
Okay. That clears that up a little. You really lost me there when I was reading through here,
Oh,
but I
yeah.
read a little fast and about half asleep, sometimes,
Right.
so. Thanks, Jason.
We have several questions. Maybe you can answer them, maybe the applicant. Do you have a plan that shows where the garage will be from the applicant?
It'll be in the same location as the old garage was. I don't
Okay.
have a site plan that actually depicts where that is on the property at this point.
Is it behind the guardrail?
It is, yes.
Okay, so this may lead down the same path I'm thinking of then. So then, if it's behind the guardrail, they won't be turning on and off the highway to get into and out of the garage. Is that correct?
I can bring the applicant up here to
Okay,
speak to that. I know there are two approaches off Highway 16A to access the property.
okay.
Mr.
Sir.
Chairman, I do have one more for Jason then.
Go ahead.
Many times, and you've run into it, after the building, we go through one of these, we approve these things, and it can be a house, and we don't require an engineer go on site and put property corners in for them so that they can measure to make sure that they hit the spot right. And then later on, somewhere down the road, and in this case, I can see highway comes and says, well, we measured from the center of the highway and the corner of the garage is on our right of way. Can we, and that's my question, can we require that they put a property corner so that they measure and make sure that this is in the right place before it goes off? This particular one's pretty critical.
Correct. I believe I don't believe it would be out of line for us to ask for a survey of that property.
Yeah, we don't need to
Prior
have the
to-
whole thing laid out, but at least give him something so when he's got a contractor, he does it himself, he knows he's got his plat to look at, then he's got a property corner he can measure over from. I guess I'd put a property corner that's on the right-of-way side, but that's my own.
So is the
view.
garage going where the window side is here that they're showing, or is it on the other side, Jason, do you know?
Yes, ma'am. I believe the existing garage was here
Okay.
at one point.
I'll just ask him a question when we get up there.
Come on up, sir.
Thank you, Jason.
Yep, absolutely. Ben Brink with Little Guys LLC, also known as Potterhouse Lodge LLC. So the Potterhouse Lodge is the subject property that we're looking at here. To answer your questions, the property was, we had Fisk Engineering come out last year about this time, and we do have that. We provided that as well with the information. So that has been done for you.
You've got a corner to measure off of.
Yes, we do.
Okay.
Yep.
Then I still think we should add that condition, Jason, would be my recommendation to you.
Absolutely. Okay.
Thank you.
Further questions for the applicant? Go
So
ahead.
Chairman, just the obvious for me, why would you put it by as close to the guardrail, not put it on the other
So
side of
it's
it?
not really seen here in these photos, okay? This unit here was our manager's quarter, has been converted over to nightly rental as well. The approach is what you're looking at on the far left of your screen. That approach goes in, and then there's a driveway that runs all the way down through by a drainage ditch below that guardrail. To the right of the house, or to the south of it, is our drain field, so it's not possible. The north is the only place to place it.
So I have a few questions then regarding that. So they will pull off of the highway and then drive parallel to the highway before they pull into the garage?
Correct.
They will not back out of the
Nope,
garage
there
onto
is
the
a
highway?
drainage ditch that is approximately 15 foot wide that sits almost 10 foot lower than the highway, or 8 foot lower.
Okay.
With a rock retaining wall that was put in at DOT when they redid the highway back in the early 90s.
Okay,
So yeah, there is an actual drive
okay.
that goes through there.
Yeah, I was surprised that the DOT was okay with the 0-foot setback. Is your plan to actually put it on the property line itself, or will you set it back a foot or two?
Well, our plan is to set back 5 foot. But as we're moving forward, it was just easier because once we get in there, there's a lot of rock and stuff still too, so there might be some movement. So it might be 3 foot, it might be 2 foot. So we just want to make sure that we had that room and that limit as to where we were at.
You understand the concern that was brought up by the other commissioner that if you go in there and you think you have it right, and some other surveyor comes there and says, I don't think so. I think you're 6 inches into the DOT right away.
Yep.
That's on you.
We understand that, and that's why, we're planning on that 5 foot or more. We just want that leeway so we're not trying to come back in 6 months or 3 months when we're doing this saying, listen, we were supposed to be at 5, but the layout put us at 2. So it's a little bit of an insurance, if you will.
This might be a question for staff. When he has the plan for this, will it come in and get reviewed for the building permit? And will you guys be able to review the setback at that time? Where he actually plans to do it?
Yes, that's part of the building permit review process, is that we make sure they meet the setbacks or they build where they say they're gonna build.
Okay, all right.
You know, one of the other concerns with property adjoining and abutting up to it, we do own all property around it. So we own to the back, and we also own to the north, the south, the east. So this is all one continuous landowner, but it's separate plots.
Okay.
That's what it
Well,
comes to.
just in case in the future that someone else does build around you, you just want to make sure it's in the right spot, whether it's
We
DOT or
own
otherwise.
approximately another 25 acres to the north. So you're going up the highway another quarter mile before you hit another landowner.
Well, you know what I'm saying, that sometime you
Understand.
might sell that property.
Yes.
Yes, sir.
Mr. Chairman?
Go ahead.
Okay. To help us out, Jason, I just wrote something up quick if you want to listen to it and see whether it fits what I was talking about.
Sure.
The owner will provide, this would be condition 8, the owner will provide and I put in quotes, property corner for construction by certified survey firm. That's about as simple as I can think.
Okay.
And if he's already got it, that helps, because I'm sure he at least had one put so that he can measure off for his construction and his
Right.
kickboards and whatnot.
Yeah, so we'll take that survey into account
Right.
when he draws out where he's going to put his proposed
I'm just
structure.
saying, would you support having that condition added?
Sure.
Okay, thank you.
I would just like to note, this kind of goes back to Deb's question early on, that item number 3, that this reduced setback is specifically only for this garage and does not apply in general to the entire property for any future items. This is specifically for this request, correct?
Yes, sir.
All right. Any further questions? Does anybody else in the audience wish to speak on this item? Okay. With that, staff recommends approval of minor plan unit development PU 21-02, and there are now 8 conditions instead of 7. Is there a motion?
I'd move. So move.
Approval?
Yes.
Second.
Motion and second for approval. Further discussion? Seeing none. All those in favor signify by saying aye.
Aye.
Those opposed, no. Motion carries. Brings us to item 8.
Agenda item number 8 is vacation of plat 21-01 to vacate the plat of lots 2, 4, 6, 8, and 10 of lots 1 through 10 in Section 8, Township 2 South, Range 8 East. The applicant and landowner is Stanley Negebauer. Other affected landowners are Elvin and Lois Rudd. Location is east of the intersection of Doenbow Road and South Highway 79. The approximate acreage is 106.8. It is currently zoned general agriculture. Existing land use is residential and agriculture. The properties, as they sit today, tax ID 19696, which is the smaller square down here, contains a residence built in 1977, as well as an on-site wastewater treatment system, and the rest of the properties are vacant of any structures and utilities. Overall, the purpose is ag. Access is provided off Doenbow Road. There's no special flood hazard on any of the subject properties. The request was sent out for interdepartmental review. Equalization had one comment about the legal descriptions and what they recommend that they be versus what was submitted. If you recall, last month the Board of Commissioners heard layout plan 20-43 and denied without prejudice to allow the applicants time to vacate the platted lots that were found after the applicants applied for the layout plan. Approval of this request will allow Elvin and Lois Rudd to reapply for that layout plan. And with that, staff finds no significant issues with the applicant's request, as it appears to be in harmony with existing lots and current land uses in the area. And staff recommends approval of vacation of plat 21-01 with conditions.
Thank you. Are there questions for staff on this item?
Mr. Chairman, just to move this along, I'm going to move that we do approve it per staff's recommendation, as this is a response to an action we took in January with this particular applicant, so that it opened the door for them to review their layout plan. So I'm going to move that we approve it per staff's recommendation.
Is there a second?
Second.
Motion and second for approval. Further discussion? Anyone in the audience wish to speak on this item before the commission votes? Seeing none, all those in favor signify by saying aye.
Aye.
Those opposed, no. Motion carries. Item
Thank you,
9.
Mr. Chairman, for that. I just thought we're just going to kill it if we talk about it. Thank you.
No problem.
Good morning, Commissioners, again. Item number 9 is preliminary plat PPL 21-06, is to create Lot 2 of Block 2 and Lot 1 and Lot 2 of Block 3 and Lot 7 through Lot 10 of Block 3 of Cedar Gulch Number 2 subdivision. Currently, this property is 121.11 acres. It is in a plan unit development, PU 0518. This commission had seen the layout plan for this request in July of 2020. The proposed lots, one of them will be 6.263 acres. The remainder of the lots will be approximately 1 acre. Here. This was routed around through the interdepartmental review process. There was some concerns from the Department of Equalization. They had some concerns on some of the notes on the plat. I did receive an updated copy of the plat from the surveyor on Friday, so they had addressed the questions. County Highway did have some concerns about the second means of ingress and egress, and I did receive a letter from the Water District Attorney regarding the water system out in that subdivision and some concerns with supply and quality of the water out there. The Board of Commissioners did approve this layout plan in August of 2020. The applicant has also submitted a subdivision regulations variance, SV 2103, to waive the requirement to develop a second means of ingress and egress and submit engineered road plans and construct the Ordinance 14 standards, and to waive the requirement to obtain written authorization from the local water supplier that there is an adequate water supply to serve the proposed subdivision. These subdivision regulation variance requests will be heard by the Board of Adjustment on March 2nd, 2021. The applicant's request is in harmony with the existing lots and current land uses in the area. However, there is concern regarding the lack of two means of ingress egress on Brideskey Road and having an adequate compliant water supply. And just an item of note, on February 24th, 2021, Section 204F of the Pennington County zoning ordinance will be effective. If you recall, this Planning Commission did approve those ordinance amendments of Section 200, and the Board of Commissioners did officially approve those, so those will be effective on February 24th. Section 204F does state, in all zoning districts, no more than 40 dwellings are permitted along a dead-end road system. A dead-end road system is the total number of roadways, dead-end and connecting, that provide only a single point of connection to a roadway that functions as an arterial. This will affect the ability to obtain a building permit for a dwelling along this dead-end road system without obtaining a separate variance from the Board of Adjustment. So I just wanted to make that note for this Planning Commission to be aware. So staff is recommending approval of this preliminary plat with conditions, and those conditions do include that the subdivision regulations variance is obtained, or those second means of ingress and egress is constructed, and that the water system is adequate to supply.
Thank you. Are there any questions for staff on this item?
Mr. Chairman?
Go ahead.
No, go ahead, Charlie.
All right. I guess when I read about these, and we see other ones come in like this, are we getting the cart ahead of the horse here a little bit? I highlighted 2, and I circled 3, that it looks to me like your conditions cover them, but I don't know that the citizens understand their conditions that are involved in it, that are closer to it, and that it's more an issue for them. In other words, they don't have the book that I have to read about the subregs to see what you've required for a condition, which is the appropriate thing here. I think you're correct. But is there any other way to treat these, Brittany?
In order for them to file the plat, they do have to either construct the road or show that the road is going to be constructed, or they would have to obtain that subdivision regulations variance. So if they do not obtain that variance and they do not construct the road, then the plat cannot be filed.
But it looks like this one's even still somewhat bound up legally of where they're bumping heads at least, a minimum, as well as there's questions as to a prior court order. So that's where I'm coming from. Should we wait? I mean, you can't continue it to infinity, certainly, for either of the parties. But I do get concerned when I see a plat, and I know it can't be filed, but when it has this many doors left open yet.
When we review plats, we have certain standards that we have to review them under, and that's under our subdivision regulations. So if they meet the requirements of our subdivision regulations, or they obtain the subdivision regulation variance, then it meets the requirements of their plat.
Okay. I guess if I was one of the citizens out there, I'd be concerned and say, do I have time to review this? I'm going to speak for myself rather than what you say. Do I have time to review this, or I better head downtown and find a legal that's going to review it? Follow me?
Right.
That would be my concern if I was a property owner or the other. And a lot of the people have an aversion, and it's financial, to walk in an attorney's office. I've got one because I don't like attorneys in the first place. I think we ought to sit there and argue it out and do it between ourselves and get it straightened out. You know, just if we had to duct tape ourselves to the chair, we're going to get straightened out. But that's my concern. In other words, I don't want to go hire a legal representative to review whether I'm okay on this.
Chairman.
Go ahead.
So sometimes, for me, it's if we're proving something, and then it goes through and we get waivers, the citizens that are buying these houses or these plats don't know that. I think that's what Charlie's saying. So they're thinking if the county approved it, it must have the water and sewer adequate in order to do this. It must meet the requirements. So when you sell something, I guess I don't buy stuff in the county. I haven't yet. Does it say doesn't have second access, doesn't have the water requirements? It doesn't say that, does it? So how are people supposed to know if this commission, either one, approves this?
They wouldn't know that unless a plat, or unless a note was specifically put on the plat. As a title company, they would just look up what is recorded at the Register of Deeds unless they specifically came to our office and asked for this plat document for the staff reports and the information that was done during the hearings on these requests.
And so the applicant's going to visit with us today about the second access and the water supply issue?
There is a representative from Long Branch Engineering in the office. He is the,
Okay.
yes.
Go ahead.
I've heard, when I sat with the county commissioners, I heard complaints about the water, the lack of water in that area. It just doesn't seem smart to me to add how many more houses to that area and not have a water source.
So there is a representative to speak on that also in the audience, and I believe he has put a speaker request for him in so he can speak to it for this commission.
When this was heard in August of 2020, it says one of the conditions that said that upon filing the plat with the register, the deed restriction also be filed restricting the residential use and issuance of building permits on all of the proposed lots. Did that carry forward as one of your recommendations?
No, it did not, and the reason that it did not is because of that provision in the new section 200 that I had read to you, the 204F.
Okay.
That covers that same requirement that a building permit could not be issued without getting a separate variance from the Board of Adjustment.
Because if I recall, and I think I was at that meeting, the conversation was that the layout plan was going to move forward, and the lots were going to be platted as essentially the paperwork associated with the result of the court case or whatever legal proceedings had happened. But there was a concern by the board about the access and the water and some of these other things, which was the requirement for these items that were listed further in the staff report. And you're saying now that the 204, what'd you say it was, F?
F,
will be in place that will then take care of this item? Because it appears that the applicant is trying to still move forward and develop these lots when I don't think that was the intent back in August. It was simply to satisfy the requirements of the order of the court.
I believe that's still the case. However, the 204F would still, so if someone came in with one of those lots and wanted to get a building permit, they would have to go in front of the Board of Adjustment and be granted a variance in order to obtain a building permit on that road. So a deed restriction is one thing. This, would be another avenue, I guess, to restrict the number of building permits on those lots.
Brittany, it says 3 lots on this one, and they're applying for 7 lots for, when the court case was done, it says 3 lots.
Yes, and I'm not speaking to the court case. I don't know if Kale can speak to that. I just am speaking to what was actually submitted to our.
But they're
To our
applying
office.
for 7, and they basically were granted 3.
I believe that they were granted an acreage, and so this would satisfy that acreage, and they're platting it as far as, I believe in speaking with them, they wanted to, since they were platting some of them, they were just going to plat them anyway, and if the deed restriction was in there or the restriction to obtain building permits, then instead of going through the platting process at a later time.
So these 3 lots turned into 7 lots? Is that what you're saying?
Correct.
Because of acreage?
I believe that there was an acreage that had to be transferred, and then they just split it up into the 7 lots, if I'm, sorry.
Commissioner Hadcock,
Colin?
Colin McNeese, State's Attorney's Office. So the court order just says that one party has to help the other party plat the requirements. It doesn't say that this board has to grant the plat or that the County Board of Commissioners has to grant the plat. I just wanted to make that clear. We weren't a party to that. We're not bound by it. We don't have to do anything with respect to that order. Thanks.
Thank you
Mr.
very
Chairman?
much, Colin.
Go ahead.
And I'm not going to hold you to this, and Colin may tell you not to even answer. You better come back. To your knowledge, how many accesses have been granted where there's 40 lots exists since we've gone with the 40 lot? That 40 lot's been in existence now for a number of years in our subregs. To your knowledge, how many have been granted? Or if you want to handle it another way, how many exist? And I think that's the wrong way to look at it. Some were grandfathered. We can't do a thing about. They were there, and there was more than 40 lots. I can think of a couple myself, having served down here before. But have any been granted since?
Commissioner Johnson, are you talking about variances granted by the Board of Adjustment?
Right, to allow this to these additional lots, in other words. How many, in other words, there's more than 40 that already exist there, and we allow 7 more. Now we've got more than 47. Do you know of any that? I sure can't remember any.
I'm trying to think if there was one.
I'm not going to hold you to it, but
Sure.
just off the top of your head, you don't.
No,
There
I know
could
that
be
there
some.
was a plat on Thunderhead Falls, but they had went from 3 to 3, so they weren't increasing density.
Yeah, I'm not including the ones, yes,
Sure.
they were that.
Charlie, this property had a moratorium on it.
Yeah,
Do you remember that? And
Yeah.
then we did let somebody already that had a house
Oh,
with a
yeah.
guest house. Remember that came through you guys?
and some of them existed that were literally just grandfathered in. They had more than 40 when we went to the 40. I can think of the one up on the hill up by the Mountain Shadows. That road up there had a ton of them on it.
One we had to, because it was already platted
Correct.
from this applicant, we had to move forward on that as well because
There,
I think there was another out by somewhere by Hart Ranch or neck.
there
the
was
Yoke.
one on Bradsky Road that was allowed to plat, but there was a deed restriction on one of the lots that it could be for egg use only. So there was no
Okay.
single-family residence.
I appreciate that. I'm just following up that this is of great concern, the 40. This is about emergency services. This is about safety of those people that live there. This is not just a number we decided, that was a cute number. This is an important number that was larger than it was ever meant to be in the first place.
We also, didn't we hear that one of the houses was built and it didn't have access to water and had to pay like $10,000? The people that owned the house didn't know they had to pay the 10,000 to get in the district or something? Was that lot that we allowed to move forward on?
The representative for the water district is here, but I do believe that that was one of the lots.
And they sold it and didn't tell them. I mean, we had to do it legally, but then they sold it and it didn't have enough water and stuff on it. So that's why I'm saying, people are selling houses, or even if you know in Box Elder, remember the issues with the water, they kept selling the lots. And no, in one sense, we're not supposed to worry about the water in here. I mean, we should, but I have a hard time letting somebody plat something and then the people getting stuck in a situation because they believe we platted it and did it for the right reasons, thinking that it could be built on. So that's my only concern.
Mr. Chairman.
Go ahead, Jim.
You know, I think sadly, most people who buy property for residential purposes like this are largely novices. They're not savvy about land rights and the mechanics of the process, and they become victims. And we have never been instructed or given some kind of charge to provide some kind of consumer protection in terms of informing potential landowners the consequences. And I think this is where we run into this problem and the people who come in here with some leverage and urgency are always the developers. And understandably, they have this land, they want to see it create some kind of yield in return. And I think it's unfortunate that we don't have specific policies that make consumers aware of what the circumstances are of a piece of property that they are, preparing to buy. And this is a perfect example of both of these issues, I think, the water issue and the issue of egress and ingress. And I don't know how many times we have said, well, it's always it never comes up until we get to the 40 lot limit. And there's a bunch of lots now that have been platted there. And somebody says, we got to draw a line now. Well, we don't want to draw a line now. And so it's unfortunate, I think, but this is a broader issue than I think than what we can do. But I find it very difficult to make these judgments with so little concern for the potential impact on consumers. And I think this is a good example that we need to approach it carefully.
Further questions for staff? Okay.
Thank you, Brittany. Thank you, Colin.
Was there questions for the applicant's agent to answer? Or is there someone else in the audience that wishes to speak on this item? Let's start there. Go ahead and come on up, sir. State your name for the record, please.
Matt Nas from Gunnarsson Palmer for Cedar Gulch Water District. Appreciate the opportunity to speak to you today. I think obviously the concerns raised via questions by the commissioners are very legitimate concerns. There's a letter, I believe it's in your packet, drafted by Talbot Wyzork, an attorney with our office, addressing some specific concerns and specifically articulating why the district opposes this platting at this time. Cedar Gulch Sanitary District was designed and is incorporated in order to provide water to the residents in this area. Because of the unique position and unfortunate position that the water supply and system maintained by Cedar Gulch Sanitary District is in, Cedar Gulch is left opposing these plats. Specifically, the plats before you are not within the sanitary district. So there is no right for them to be necessarily hooked up to the district's water system. Discussing the specific issues that the water system has. When the water system was installed, there was no storage included within the system, so it's there are several fire hydrants within the system. However, they can't be used for fire suppression because there's not adequate storage within the system to provide the flow necessary. The water source itself provides for 70 gallons per minute of water. However, that's not sustainable long-term, which exacerbates the lack of storage issues. Aside from the quantity of water issues, there are very real quality of water issues that I think are addressed in the letter. You've seen the results of the South Dakota Department of Environment and Natural Resources testing of the water. And most concerning, obviously, is the high levels of radionuclides contained within the water. Those high levels of radionuclides have required sole source treatment of the water. So we're talking in-home treatment of the water. They do water softeners and they do reverse osmosis of all the water that goes into these homes at their homes. That was required by DENR because there are access issues with the well. The district was unable to treat the water at its source prior to being transferred into the system, into the homes. So the district itself, through its tax dollars, has an agreement where it provides salt for the softeners and provides for the reverse osmosis and the maintaining of that system. In exchange for allowing them to do that, DENR requires a third of the homes in this district to be tested annually, especially for radionuclides. The district, as a governmental entity, is able to require its members, those getting water from it, to comply with these restrictions because it's a governmental entity. If you were to add homes not inside the district, there would be no manner in which to require that those filtration systems be installed and maintained and tested in each individual home. Sorry, my mask here is riding up a little bit. So that's why I'm here today. The district opposes any plats here. As has been addressed by the commissioners, the water system is a real issue here. These residents most likely unknowingly inherited the situation with this water system, and they've had to deal with it. And adding additional homes to a system that can't handle, based on quantity and quality, that system is a very dangerous path, which could very easily lead those individuals who buy these lots into real trouble, and also leave the district into real trouble should they be in some manner required or asked to hook up these additional lots to the water system. The district would respectfully request that you deny the preliminary plat before you this morning. Are there any questions?
Yeah, Chairman.
Go ahead, Deb.
So did Gordon Howie, he's the one that sold the lots to these people that have inherited this water system, or was this a different developer?
I think the letter says that it's our understanding that there was some connection there between Mr. Howie and the purchasers of the lots. What that is specifically, I can't tell you right now. But
Right.
it's our understanding that there was some, yes.
So when you plat lots and you're a developer, you make the water system and you have the sanitary sewer to prove, right? Am I correct, board?
Yes.
Okay, so he had to prove that
Typically.
that water system and that well was adequate, or basically wasn't contaminated in any way, and that the lots could take, that many lots could take that much from that well and that kind of thing?
I can't speak to the specifics on that. If the lots are a certain size and there's a water system that's being proposed, then I would say yes. If the lots are a little bit larger, I think by state rule, you could drill your own well on your own lot. So I've seen it handled several different ways in the past 5 years since I've been here, so.
Yeah, but isn't it past 25 or something, Brittany, or something for water? So didn't he have to prove that this well wasn't contaminated? Was it contaminated later? I mean, I guess I'm trying to figure out the radionuclides and a few of the other things that I keep hearing about, if that was, a problem from the beginning. I mean, How does the well work, Brittany?
Sure. So 15, it's either 15 connections or 25 people. That's when it becomes regulated by the state as a community water system. I do believe that because of the number of connections that are currently in this subdivision under the Cedar Gulch number 2, they meet those requirements, so they are a community water system. I did speak with Mr. Wazorek last week. My understanding is that they've had continued problems with radionuclides in this area based upon the formation and the locations of the wells in this area. I don't know if drilling alternative wells would help that situation or not. I'm not aware of if they've done any test wells to find out if it's just that area, that formation, that they have those issues. But I do know that they have been in noncompliance with the South Dakota Department of Environment and Natural Resources as far as not meeting the radionuclide requirements. In order for them to continue to utilize their water system, they had to do these treatment systems that Mr. Nas has spoke of in order for the state to let them continue under their water district as their water system.
Okay, thank you.
Mr. Chairman,
Go ahead.
I served on water boards too, and there are restrictions that involve the federal. You jump to a certain level and federal testing and certain personnel you have to have on. They are probably not at that level right now. And you're talking paid full-time people that they have to have on. Although I have a strange feeling in this case where it met the state requirement, the feds are involved in it too because of the particular contaminant that's in the water, would be my guess.
So
In
Charlie,
fact,
how much contaminant, how much contaminant is too much where they just shut down the water systems?
well, they have guidelines for all that and.
So they have to be passing if they
No,
let them keep
absolutely
going.
have
And
guidelines that would drop the hammer on them, correct.
May I?
Please continue, sir.
And that's why those point source treatments are in place, because the water coming from the source doesn't pass the necessary requirements. And that's why they test a third of the homes to make sure that following the treatment, the water does pass the drinking water quality standards.
so they're called point source treatments and they have to go in each house.
Correct.
Thank you.
And they consist of reverse osmosis and water softeners.
Can I finish? If they had developed the whole development based on the initial lots that came in, I have no doubt they would have fell into the federal level of water qualities and whatnot, like our Chapel Valley was. In other words, that was much bigger than a state level or requirement because of the amount of homes. There were 600 homes off of that water system. And I think the break is below 100, so, and I think there was 100 and some lots on this. Am I correct on that, Brittany, or do you know
Brittany's
that?
done this for a while.
No, actually, the 15 lots, 25 people is actually a federal requirement.
It is.
So the state does take primacy over those drinking water requirements. So they are the ones that regulate them, but they are
But
federal
once it gets
requirements.
to serving a certain number of people, then they have to have full-time employee, like a manager and things like that. I can remember
Correct,
those
it's based
guidelines.
on size and things like that, and then it's the level
This
of.
one just hasn't reached that yet, and
But they
probably.
do have a person that
They
manages
do
the,
have a
yes,
full-time manager.
yes.
Super.
How
They have
many
a certified-
people,
I'm sorry.
how many people are on this system right now that are users?
You know what, honestly, as I see it right now, I don't know the answer to that. I can tell you that there are 3 lots that are within the Cedar Gulch number 2 that have not yet been built, and that's one of the issues. So those are already platted lots where building could occur that will additionally tax this system. And so then you've got to add the 3 additional lots that are already there, and then 7 more on top of that, perhaps, to try to draw water from this system.
But I mean, how many homes right now are being served by this system?
And I'm sorry, sir, as I said, I can't.
Does anybody have any idea? 100, 5, 15? We gotta have some idea here.
I'm trying to count up there. Yeah, I think there's
it was
around a
in it, so
dozen.
It's only like 10 or 11.
I think it's around a dozen, sir.
Yeah.
Okay. Well, yeah, it seemed to me it was a relatively small system at the moment.
So Matt, legally, are they legally in this district?
Not right now. No, ma'am, they're not. The plat, and I think it was included as an attachment to the letter, shows the 2018 Cedar Gulch Sanitary District Number 2, and it does not include these parcels of property.
Okay, because you kept saying in the district, and it was like, are these guys already supposedly in the district? And then they just don't have enough water to be added to the district?
Right, they're not currently in the district, but this would be the local water distribution system at this location.
In the area,
Right.
yes, sir.
And again, one of the reasons that it's a problem is because they're not in the district.
The district information from the state. So there's 39, it says population served and 13 connections. Oh, you're welcome.
Thanks, Brittany. That helps.
And I would say, Commissioner Johnson, to your point just a minute ago, there is a certified water operator that handles this system.
Hope you didn't take it personal. Attorneys do provide a good service. I just,
If you go against
good
them, make
service.
sure you charge
I'm
them.
saying that the service is paid for by scarce resources, which is dollars. And that's would be my next question to you. In just your knowledge reviewing, if this continues to move forward, is this going to create an extreme situation financially? I'm not saying so you get paid, but so that they can do their mission?
I think that's a very legitimate concern, especially as you look at the population served and the numbers of connections. So you're dividing large costs by a very small number of residences. And if you have to make major upgrades, both to quantity of water available, if you have to try to find a way to get access to the water source so that you can centrally treat your water, you're going to ask these few members of this district, or few residents within this district, to shoulder a very severe financial burden.
Okay, and they are not currently meeting any fire hydrant requirements or anything like that, because that's an extreme supply condition.
Sure, I think my understanding is that the district has 8-inch lines, so there's some water storage just within the lines itself, but there's no other volume of storage to maintain the pressure that those hydrants would need
to meet the state requirements.
Right,
correct. Thank you. In other words, and insurance companies get involved in that. Mm-hmm. I mean, this is serious. Again, it's this. Just like we were talking about, these fire emergencies and emergency services begin to become a critical factor for these people in these locations.
And the question is, are we going to let 3 to 7 lots more have the same type of water with the same type of system, even if they formed a different district? Is that how we're moving forward? And bottom line is, if they're going to sell the lots, so they don't get in the district, they start a new water system, they do their second access. Brittany, just a question for you, there's problems in the area of radium and different stuff in the water, then he'd be selling 7 more lots or 3 more lots, whatever is decided, and those people could form a different district and have the same type of water and same type of stuff, and that could be legal to do?
They could form their own district, yes, and drill their own wells. What if they would have similar issues? I would believe that area would have similar issues.
Right.
But, without doing the testing and the drilling, I do believe that these wells are actually fairly deep, to my knowledge.
So that's what I'm trying to say. So, okay, they don't use these guys as district, they don't use their water system or sewage system, then they do their own. Then they could prove that they're gonna do that, and there's a variance to the road, second access. That's how we'd have to move forward if this board wanted to move forward, because obviously that district legally, Matt, if I'm correct, does not have to give any more lots access to their water or their sewer systems, right?
I'm sorry. That would certainly be our position, right? Because they're not within the district at this time.
Mr. Chairman.
Go ahead, Jim.
So what would be the legal circumstances under which this district would be required to act in a way that they presently don't wish to? In other words, is there some legal mechanism that would require them to provide, if we were to plat this property, is there some mechanism that could be put in place? What would the legal argument be?
I'm sorry.
A lawsuit.
Go ahead, sir.
And as I stand here right now, another question to which I don't know the answer, and I apologize for that. But I think the point is that the water source that's available in this location for residences in this location, is that maintained by the Cedar Gulch Sanitary District Number 2. And so I think it goes to the point addressed earlier by the commissioners, is that you've now got these plats which appear to be within that district, and so you're going to have homeowners potentially thinking that they can get access to that water system there. And as of right now, there's been no conversation about bringing these lots within the district.
So Matt, is
But,
there
but
a
what's the legal argument? Why would the district have to say, okay, we're forced somehow to provide water? Why would they be compelled to do that? I can see why they might do it in their own interest. The new lots may decide to all drill wells, which may affect the quality and quantity of water that's in the system now. Maybe that's an issue. But what is going to compel them to do this?
I don't know that they would be compelled to do that.
But and there's no. Yeah.
But the concern, however, is that you're going to be stuck with landowners and homeowners who are now left with no other viable water source in that location on an acre-sized lot drilling a well, for example.
So Matt, there's a District 2, guys. Who's District 1? And where's that at?
Can I throw in, because it's kind of an answer to this question, and I think you do know the answer to this one. I read what you wrote, and it appears even if we move forward again with this issue, that there comes a point here they cannot borrow any additional funds. They're not available to borrow because they're kind of stuck in a catch-22 situation. They can't do a water study. They can't look at additional things for funding because it's not available to them. Is that correct?
That is correct, but that's the current district, the members of the current district. And that stems in large part from the access issues to the well site, because there's not a.
But my point was, if we made this part of the current district by our vote, the funds aren't there, and neither is the borrowing to be able to develop, is what I'm saying. They don't have the normal channels to go through, private or federal or state.
That'd be up to them, Charlie, if they wanted to add them to the district. They could,
Yes.
if the developer wanted to make it do district, they could. But where's District 1 at? We're talking about District 2.
I'm just saying their officers
No,
that
I'm
are on
just
their
saying-
board of directors have a fiduciary responsibility, and if they don't have any available capital to do this with and no sources to go borrow the money, no matter what we vote, they can't do it.
Well, if they sold more lots, then those people would be liable. But where's District 1 at?
Yeah, let's answer Deb's question. I'm looking at the plat. It just says Cedar Gulch number 2 subdivision, so maybe that's why it got number 2. I don't know if there's actually a number 1.
Is there, Brittany? Okay. I keep hearing about 2, but what's up with 1's water and sanitary and all that? Is it close to them? Is it?
It's just south of this.
And do we know anything about their water and their sanitary sewer, and can they hook up to them?
It looks like they serve 45. They have 14 connections. Their contamination risk is high. Let's see.
How many connections
they
to one?
test for radiologicals annually also. Let me see if
How many is connected to District 1?
45 people and 14 connections.
14 connections. Thank you, Rich. So
it
we're just continually adding to districts, adding with crazy water systems, and so legally, Matt, you're representing District 2, where this could be District 3. That's the unfortunate thing, and that hopefully people, I don't know,
And that's
understand that. If Cale comes up and says he's doing District 3 and he's doing a sanitary sewer system, legally, he can do that, or the owner can do that. So unfortunately, District 1 has the same issues, then District 2 has the same issues. Be interesting to know if District 2 knew about District 1's issues beforehand, but.
A powerful argument for living in an unincorporated community. And I've lived in both, so I know.
And that's why we're asking that these plats be denied until such time as the water and frankly the access also, but are figured out.
But Matt, we can still legally, for us to plat them, we can plat them. Like I said, not to go into District 2 and not to use their sanitary or their water, but make a new district. that would leave your District 2 and not have these people connected to it, but put it in a different district.
I think that's possible. And we would ask that if you do intend to plat them, that you put a restriction on the plat specifically addressing the water issue that says, no building permit will be allowed until the water issue is resolved, whether that's through inclusion within number 2 as we're referring to it, or some other mechanism. But the problem we want to avoid is a building permit in a home in that area right next to Cedar Gulch Sanitary District number 2 that's now looking to us to be a supplier of water, and we don't have the capacity to do that either from a quantity perspective, a quality perspective, or a funding and borrowing perspective.
No, I have that understanding, but if they decided to, like I keep saying, if they decide to do District 3, they don't use their water, and they know about the water, and they tell the applicants, and then they do a point source treatment on each house, in each one, legally, they could do that.
Commissioner Hadcock, what I think that you're asking is if you were to approve, this commission were to approve this plat today, preliminary plat with the conditions, that if they were to somehow address their water system, whether it's creating their own water district through the Secretary of State's
Yes.
website, getting access through Cedar Gulch number 2 sanitary district, perhaps even Cedar Gulch sanitary district number 1, if that would be legal, correct?
Well, they could do their own well and not have to even worry about 1 and 2, couldn't they?
Yes, I think
Gail?
that might be correct based on what Brittany's told me of the Diener and then my quick perusal of Diener's requirements. So I think that there's, to use an old phrase, different ways to skin a cat.
Yeah.
One of them would be just to leave it open, the condition that the water issue is resolved to make sure that it's adequate and safe for everyone. And then just leave it open-ended, whether they want to go to Cedar Gulch number 2, 1, or their own, or what have you, whatever options are available to them.
Thank you. Kale, can you come up and answer some of our questions? Thank you.
Please state your name for the record when you get to the podium.
Yeah, it's Cale McNabo, Long Ranch Civil Engineering.
Did you hear all our questions?
I sure did. I want to pull the plat back up. Maybe we can, it's been a long time since we were here last with the layout plat. So I want to think a little bit about, if you don't mind me just starting at the start on this one.
Go ahead.
There was a court order that ordered the transfer of the parcels. The question became, how do we transfer it? Now, because there's right-of-way dedicated here, it makes everything north of this road non-continuous, so there has to be one plat. These group of lots are separated with 4 existing, so that's what dictates the fact that these can't all be one lot. They're not continuous.
So not to stop you, but did you read equalization and
Yep.
Register of Deeds, so you changed that
Yep, and
already?
that got addressed.
Okay.
So then the question becomes, how do we transfer? What's our vehicle for transferring these parcels? Rectangular lots can be transferred by legal description. You're there quarter, and 200 feet. That doesn't work as soon as you get a curve in it, because how do you describe a curve by legal description? You can't describe them. They're irregularly shaped parcels. So if these were not irregularly shaped parcels, you could do them by legal description. We wouldn't have to go through the platting process. But because there are irregularly shaped parcels, we have to plat them. So the idea being that, Mr. Howie, who owned this, originally had this grand scheme of planting some 80, 90 lots out here. That did not obviously go through to fruition. A sale happened. Anyway, the court order came through requiring the transfer of the parcels. And we're just searching for the vehicle and how to transfer the parcels. So if I didn't arrive at a plat, I wouldn't have be sitting here asking you this, other than I don't know how to get around platting it.
So, Kale, Mr. Howie's not involved except he's selling the lots.
Oh, no, he is due the lots. The land has to get transferred back to him per the court order. So I don't know what he's going to do with the lots. As I understood the last time we had this conversation, there's going to be a building restriction put on these lots. So they're not going to be developable anyway, but it's going to allow, the platting is going to allow the transfer to Mr. Howie so he can take ownership of them because he doesn't own them right now.
So he just wants to plat him. But we went to court over once he platted him, that we had to let him go ahead and get his building permits. Do you remember that?
I don't remember that one. I was involved in that one.
Hey, so why would we do it again?
I just don't know the vehicle to transfer these aside from this process.
Well, he can't create a transfer unless he gets it platted. But then when he gets it platted, he's gonna come to us and say, okay, you did this to me before. So we platted it. Yeah, we had an issue because once we said he could plat it, right, Brittany? Once we said he could plat it, then he came back and said, well, you said I could plat it, you offered me the plat, you approved it, and now why would you have me plat something I can't build on?
Yeah, was there a building restriction on the last one that got approved?
I believe that there was the previous planning director denied the building permit because it didn't meet that 40 lot rule. So he came in front of the Board of Adjustment, and then the Board of Adjustment agreed to allow those. I believe there was like 2 or 3 building permits.
But then the judge said since it was platted, I thought, or the people said since it was platted that we had to do it based on, didn't matter if the 40 unit rule was, and Shadrach was up here saying, well, why would you plat something if you're not going to build something on it? And that would be Shadrach Howie.
My understanding is because it was previously platted, that the building permit had to be issued.
That's what I'm saying.
Yeah. So I guess maybe I'm not completely understanding, but
So he
Well,
wants to
that's-
transfer it so they go back to him, but he needs it to be platted, Cale.
yeah, he needs.
So if he has to get it platted and then he comes back again and says, well, I platted it, you're gonna tell me I can't build anything. But then there's building restrictions. This whole thing is just crazy to think about, because then he wants to plat it, then he wants to build it, but then he's gonna come back with building restrictions. Why would you go through all that just to plat something that you believe you can't do anything because it has building restrictions? Why move forward?
I think he just wants the land. And why he wants the land, I can't speak for him. He's not here.
Well, I'll speak for him. He wants to plat it and build on it.
You know, like, I guess once either the water or the secondary access issue gets done, I expect he does want to build on them. That's why,
That's why he's
But-
platting them.
yeah, I'm sure he does. But I think the basis of it is that we need some sort of a legal document that says it's a building restriction on there, and maybe the county commission requires him to sign an affidavit saying he understands that there's not gonna be any building permits issued, and then you have documented proof. of
Okay,
the
I'll be
trail.
up straight. The affidavit sounds good, that he'll provide a sanitary water and sewer system and show us before we plat it. And also an affidavit showing that he's putting in a second access again, because last time they didn't get an affidavit, but he declared he wanted to put in the second access, never happened. And that's why all this is happening. So bottom line is, I'm into affidavit if he is, before I plat this legally. This is me personally, so.
Yeah,
Mr.
and
Chairman?
this thing won't go forward to the county commission until after the variance applications have been heard. So I really think the contentious back and forth is gonna happen next week at the variance application.
Now why I'm up there, you mean?
Mr. Chairman, I concur with what you're saying about the variance.
Go ahead, Charlie.
I think this goes even farther, Deb. We've got an exposure here because you have the right as a property owner, as our chairman pointed out, to drill a well. We certainly, with our knowledge of the water conditions right now, would have some idea that that well may not have acceptable water. And the state only comes in and does a cookie cutter test. So have we handed him the ability then, the cookie cutter test involves collates and fecal only.
So
And
Charlie,
then
is
do
it
we give
water,
them the right to build then?
is it water quality or water quantity? Because if they get water quantity, the people out there already have a, whatever,
If they drill a well on their
Personal-
own site, they don't even have to go with a quantity. The quantity's so slight that if you flushed the toilet while somebody was in the shower, you'd probably kill them. That's how little the requirement is for quantity by the state out of that well.
I'm just saying in general.
Well,
Oh.
I'm just saying, I think if we vote that thing through that you're talking about, that we've opened ourselves to exposure because we know the water's no good in the first place. He
Well-
could still drill that well.
If it's no good, then we're just telling District 1 and 2, and they've been living with it with a personal whatever source,
at
then,
extreme expense out of their
right.
own pockets.
But that'd be a personal choice if the next people wanted to do it. I'm not saying to agree with it,
They're
I'm
not going to
saying,
get tested for that unless the state comes back in, and they haven't yet, and comes back in and says, hey, wait a minute, we're not going to let you use your private well unless you test for this too. The test they have to pass when they hire the well driller, and then Mr. Howley's going to have it, or whoever's the representative who's trying to attempt to get this for building. They're the ones that are going to say, well, the well's on the site and it has the proper flow.
okay, Colin, based on our rules and regulations, tell us where we're going next.
Well, I just want to reiterate that under state law, any
There you
person
go.
who wants to subdivide has to meet all of the requirements. One of those requirements is the subdivision requirements. If all the subdivision requirements are met, then the plat must be approved and filed.
So do we have to approve so he plats it today because he can,
No, what today is my understanding of what the planning department has done is they've conditioned approval based on certain stipulations. I don't know how many there are. One of them is the water issue. One of them is the secondary ingress and egress. If Mr. Howie, as the subdivider, does not meet those, then he cannot file it with Brittany, have Brittany approve it. Brittany doesn't have to approve it at that point because it remains discretionary until that is, so this board and the county board controls until it becomes
so
ministerial.
legally today, we do not have to agree with this because he's not meeting the subdivision regs.
You are correct. There's a number of options that you could do today. One would be to deny it. One would be to continue it to a later date after the variances. Or you could go with staff's recommendation, which is to approve with those conditions. And knowing that with those conditions, he can't file his plat. His plat is not effective until he meets all of those, has proof filed with Brittany, and then Brittany can sign off on the plat.
So we can continue it today as a planning commission until the variances are met and then bring it back. That sounds a lot smarter than us bringing it forward thinking we're okay.
That's certainly one of those options. But again,
Suggestion.
if it's approved today with all of those conditions and Mr. Howie never meets those, then the plat will never get filed. It'll never be effective. He'll never have.
Well, I just don't want to play the game, meaning that the planning commission just moving it forward because it needs to do variance. It makes more sense if I'm a planner or a person on this planning commission today to continue it, see if those variances go through, and then decide, okay, the variances didn't go through, why would we even plat it?
Well, that's up to this commission how
Just
the
saying.
commission wants to proceed. But those are the three options that I see.
Brittany has something. Sorry to talk too much, Rich.
Actually, there is a fourth option. There is the ability in our subdivision regulations to require assurances for any improvements. So you could require bonding and things like that too.
We could do that when he comes back to the planning, can't we?
This is the planning commission, this request, this preliminary plat is the last time this board or this commission will see this. The Board of Commissioners could do that. This planning commission could recommend assurances. So that is option 4.
But if we continue it, it will come back to this planning
Yes,
after
if you
this.
continue it, it
Okay.
could come back, yes.
Thank you.
Kale, do you have anything else to add?
Yeah, I guess I don't know why we'd continue it. The real discussion's gonna be at the variance. So if the discussion at the variance happens before the county board, then let's say that he does wanna go, build the water system and build the road. Why would we deny it?
Because, Gail, just like I told you, you would not want to plat something before the variances went through, because if the variance don't go through, why would we put a plat on it, making people, if he sells it or not, thinking that you could do something with that land?
Yeah, and I get that one, but this, before the county board approves the preliminary plat, the variances are going to happen. We just moved it through this meeting, and we can wait till after the variances. But let's say that he plans on going back and building these improvements, then we still just have to circle back. The variances got denied. He's got to build the different improvements, and we're right back to where we started at today. All this does is it's going to delay it out further and further, and you can see that.
But this point is gonna be delayed for a while anyway for him trying to figure out what he's doing, Gail, so
Yeah.
I'm not trying to be mean to you, Gail, because you work and you actually do some really good work, but in this case, I think you're getting the cart before the horse.
Okay.
Mr. Chairman,
Go ahead.
I kind of concur with Deb here. This isn't the best outcome or answer for you. But the truth is, we're involved with a situation that I don't trust the outcome. There's going to be additional court review of this. And we don't come to these meetings. You have to understand when we're trying to look at a thing and do the appropriate thing. We don't get advice before we come in here from legal people telling us where we should land on these things. And in this case, I don't trust the answers out of courts anymore. They can come in from a left door or right door, who knows? And you know that. And I think we've got to, for the county, to take a very conservative approach to it. And I kind of agree. I believe that we wait to see the variance next, and then we talk about what we do, depending on what the Board of Commissioners do with the variance.
Okay.
That's my opinion.
Back in August, when, was it August, that this was heard before the Planning Commission, there was a very specific stipulation on there that indicated that, that that a deed restriction be put on these lots, and that's why I went forward with that. Now, there are subdivision variances, that have been submitted, that appear to go against some of the stipulations that were put on the layout plat to move this forward, simply so the property could transfer. Completely understand the reason for the platting. You need to be able to legally describe and note the property for the transference of the property. Yet the access and the water issues still remain, and they remain unanswered as of today, from my opinion. So I will be in favor of continuing this to understand what happens at the variance. Because I think that the deed restriction should have been submitted with the preliminary plat, and it doesn't sound like that has happened.
Mr. Chairman, I'd move we continue PPL 21-06 until such time. You want to give us a date?
March 9th, maybe.
March 8th or March 22nd.
Okay.
So that both sides of this can have some idea the next time they're going to have to appear and talk to us.
Sure. The subdivision regulation variances will be heard by the Board of Adjustment on March 2nd. So the two meetings in March for the Planning Commission are March 8th and March 22nd. So you could continue it to March 8th.
Okay,
or
let's give them some time to react then. Let's go with the 22nd as my date. And I would like to include one additional item in that. If it is then carried forward or continued for some reason with the Board of Commissioners, that our date be accordingly the same. In other words, give them a couple of weeks then to sit down and prepare to come back here.
Charlie, you could just come back, and when it came back, if it's not settled or it's not done, you just continue it on March
Okay.
22nd further, sir.
Yeah, we don't want to muck it up for them or for us, so I agree. Let's go with the 22nd. That gives parties some time to review it, and something needs to break on it, so let's go from there. That would be my motion.
Is there a motion and second? Further discussion? Does anyone else in the audience wish to speak on this item? Seeing none, hearing none, all those in favor signify by saying aye.
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 Those opposed, no. Motion carries. Brings us to item 10.
Hopefully that'll load. Kozak, environmental planner. Item 10 is Plan Unit Development Overlay PU 21-03. And it's to rezone 40 acres from General Agriculture District to a Plan Unit Development Overlay District to allow a seasonal event venue / specialty resort. The applicant is Yardley and Company, Inc., Shelby Woodland. She is in the audience if there's any questions. The property owner is Rick Johnson. The size of the property is 80 acres. The PUD overlay will be only 40 acres. Staff is recommending approval of Plan Unit Development Overlay PU 21-03 with 29 conditions. Criteria for approving plan unit development: that adequate utilities such as water and sewer be provided. The subject property is supplied water through West River, Lyman Jones Rural Water System, and the subject property has an existing on-site wastewater treatment system and porta potties will be used when needed. The septic system is sized for 150 people per day and one RV hookup. The applicant will have one porta potty on site. The applicant sent me an email later in the week that she is working with DENR on resizing the system. The information that was given to DENR wasn't accurate, so it'll actually, the system will be enough for the 200 people that she's requesting, plus the RV hookup without the one porta potty being permanently on site. Number two, that adequate measures have been taken or will be provided for ingress and egress. Roads that will be used to access the subject property are Quinn Road, which is a 24-foot wide paved road, Bigfoot Road, which is 24 feet wide gravel, and Kelly Hill Road, which is 24 feet gravel. Access to the property will be off of Kelly Hill Road via a 24-foot wide approach. The adequate off-street parking is provided. There will be a total of 46 off-street parking spaces. This is enough to accommodate 200 people plus 10 employees, and that there's an adequate plan for fire mitigation. The applicant has contacted the Quinn Fire Department about the proposed uses on the property. There's also one fire hydrant and fire turnaround on the subject property. The applicant has also submitted an evacuation plan that shows exit doors, windows, and location of fire extinguishers. Excuse me. On June 11th, 2018, the applicant did apply and get approval for a conditional use permit to allow for a specialty resort. But then on August 22nd, the Planning Commission ended the conditional use permit CU 1804 per the applicant's request. Access is off of Kelly Hill Road. There is no special flood hazard area on the property. It is not studied. This was routed out for interdepartmental review. There were no comments or concerns from any of the departments. The applicant is requesting a specialty resort to allow live music events, weddings, caterers, food trucks, markets, community events, beer, wine sales, rental space, overnight, rental camper, canvas wall tent, primitive camping, dry RV camping. This will all be ran out of the existing barn that's on site. And again, staff is recommending approval of PU 21-03 with 29 conditions.
Thank you. Are there questions for staff on this item?
So water and septic fine?
Yes.
Could you explain the overlay district, or the overlay, if you will, on top of the general agricultural district, and how that's different than rezoning it as planned unit development?
So when you rezone it to planned unit development, you change the setbacks, you change the uses, you change the overall, I don't want to say structure of the property, but the overall uses and everything of the property.
Okay.
Whereas the PUD overlay, you still have to meet the underlying zoning district requirements, so she still has to meet the 25-foot setbacks and all the gen ag stuff. What we use PUD overlays for, we're not doing actual PUD rezones anymore. We're doing overlays. They're ran kind of like a conditional use permit, but it's for applicants who want a lot of things where you'd be running 4 or 5 CUPs and instead of just one PUD that has to be reviewed instead of a bunch of CUPs.
Okay. Next question. Will there only be one planet unit development overlay allowed on a parcel? They can't have overlay on baseline property?
No, they would have to come in and amend that PUD to include any extra uses that they would like.
Is it like a minor? Do they call it a minor when they do that?
Minor or major, it depends on what they're trying to change.
Like you did today, Rich, on one of the PUDs?
Okay. Last question is so they are not asking for any variances to any of the underlying property zoning requirements?
Correct, no.
Okay. Thank you. Go
One
ahead.
question. Why do you have it 6 months instead of a year for the PUD review? Because you have be reviewed in 6 months, the PUD be reviewed in 6 months.
So I put 6 months because a year from now would be February again, where they're not operational. In 6 months, they could be operational, so we'd be able to see how things are actually operating on the site.
Good point, thank you.
So that's a picture of the barn.
Yes, that's the picture of the barn, and then this is the inside. This is the loft area.
I had a concern when I read that it was built in 1920. I thought,
Yeah, they have building permits to redo the inside of the barn, and then that small window that you see at the very end, there's a deck on the outside of it. They're putting in a double breakaway door for another fire exit up top on the loft.
and the other question, what's the nearest residence as far as sound? How, are there any nearby neighbors?
There is. I don't know if there's actually a house here. There is some sort of. It looks more like a quarry than anything to me, or some farm stuff, but I do not believe that there's a residence there. So.
I'm Shelby Woodland. Hi.
Hi.
It is a residence. It's also a century farm, I guess. So a mother and her son live there, and his daughter, I guess. So we know them very well. They have my full application, and we discussed concerns, and they don't have any concerns. So.
Thank you.
Shelby, is this in Quinn?
It's the address is Quinn. Yeah, specifically.
South Dakota?
Yes.
North.
I applaud you. I think this is a pretty cool that you're
It's a
making
ways out there, but yeah.
Yeah, that's why I was like, okay, you want to, well, there's a lot of residents and people that maybe want it a little more secluded, so
Yep. It's a ways out.
thank you.
Further questions for staff or the applicant?
Karen, did you have? I do.
Go ahead, Charlie.
Okay. And this would be for Cody, just trying to understand and I'm sure you've read the conditions too, and I'm trying to understand them. Excuse me. The way I read it, our capacity, our maximum capacity is 200, correct? Okay. The RV rental hookup, I take it that's the only one that's a wet, dry condition.
There will be one RV hooked up will be hooked up to the septic system that is allowed to, that they plan on renting out.
And the well if they want, I suppose, then.
And the what?
The well, water,
Be connected to the well.
is it hooked up to the water?
We are not on well water. Is that what you mean?
Yeah.
We're on rural water.
I believe
Okay,
it's
but it's hooked up to
I believe
public
it's
water.
hooked up to the
Yes.
hydrant there.
The
yes.
rental RV.
Yep.
Okay. So at least I understand that. All right, then we go to number 9. It says that a porta potty is provided to the primitive camping and the dry RV campsites, of which the only way I could understand dry RV campsites was come over here and the maximum be occupancy. I don't understand how that's written. I think there's just a clerical error in there. 10% for both tent camping and RV camping. Now, that would mean the door's wide open on how many dry campsites to a maximum of one porta potty per 50 guests, so you could assume that they've got to serve the 20. Follow me? I'm having a problem seeing how many dry RVs we got out there.
So there'd only for what she proposed was 10% of the maximum capacity for both the RV and the dry temp camping sites. So there'd be no more than 40 people.
So humor me. I'm saying we have no camping. Tell me how many RVs you expect to have camped out there dry.
20. And I don't have any hookups, so it'd only be 20 dry RVs. There's no
20 people or 20 campers?
20 campers, 20 RVs.
See, now that I don't read in here. Do any of you read that? That we're going to have, besides the rental one, an additional 20 campers?
If there is 20, is there an issue with that? I mean, what's the issue, Charlie, is what I'm trying to say.
We don't have people go out and count these things and go through them. And we've got porta potties, we're saying 1 per 50 guests. People could follow rules thinking they're following rules, and next thing you know, we got 40 campers out there because we got the right number of porta potties.
40 to 80 acres with not a lot of habitants out there.
Well, I know, we
Just
still got
saying.
neighbors.
Just, yeah.
we
40
write
acres.
these conditions in here. Either I have some strength and they're meant to be
Yeah.
gone by, or we don't. I'm saying the door's wide open. You could have 100, the way I read them.
If, put
Do you
20 then,
recommend,
if that's what she said.
yeah, do you recommend a change to one of the?
I don't know. I didn't go out there. Cody, you'd have a lot better recommendation on that than I would, how to look at.
Shelby, you're okay with 20, and then if you have more, you can come back and change your condition,
Yeah.
ma'am?
That was my intention,
Okay,
yeah.
thank you, Miss Shelby.
Is that something that you think is livable?
Yeah. Yep.
And I think we can still meet the porta potty thing by that. In other words, if you apply so many people per, you've got the right number of porta potties then. In other words, 20 is probably going to have 100 people, a couple of porta
So
potties.
Cody, put it like a stip, if that's okay with the planning for 20.
You know
and
what
then
I
if
meant
Shelby
by dry
changes-
camping? In other words,
Yeah.
they need the porta potties, so we
Well,
want to get that
Under dry
condition
camping,
right.
just put 20 campers or whatever, and if they change, Shelby, if you change it, then just come back and tell Cody. So
Which item is that?
is that okay with the planning commission?
What item is that?
What one is it?
What condition is
Well,
that?
it ends up affecting number 9, the porta potties, and then number 13, you could put the 20 in there, not to exceed 20 campers or something in 13, and
Dry
then
camp-
that would
Not to
change
exceed
that.
20 dry camping sites.
I guess,
or something.
and I'd count on your wording. Don't get me wrong, but I'm saying so that it made sense to me. Anyway, I don't know, maybe it already makes sense to
Cody.
you.
So we can change that and say instead of maximum occupancy, we can say that only 20 tent sites and 20 RV sites are allowed on the
Sure.
on the property.
As long as we've got the
That
right
what you
number
want,
of porta
Charlie?
potties to help those folks out and do the appropriate thing, I got no hang up on it.
So staff would be fine with rewording that condition to allow 20 dry campsites and 20 dry RV camping sites.
I don't know what the use of a porta potty is. It 50 people? I assume you were going by what they recommend.
Right. I would just recommend that you say that the combination of them not to exceed 20. So you could either have 20 RVs and no campsites, or 20 campsites and no RVs, but otherwise, I agree with you, it sounds like you can have 40.
Okay.
Okay.
Guys, work on the final wording of that. All I'm trying to do is pin both together, so you've got the right number of porta potties, or you're required to, and if you're required to, I know you'll put them there.
Right,
Okay.
and I think I was a little bit confused because I am applying for 20 dry RV sites and 20 primitive walk-in camping
Okay.
sites. So the wording is a little odd there, but when I applied for 10% dry RVs and 10% tent.
So you want 10, all right, so you want 20 dry camping sites and 20 dry RV sites.
Yes, yeah.
Okay.
You're okay with that, Brittany?
I just wanted to make sure it was clear, like,
Okay.
the maximum.
So where's the stipulations and where do we put that at, Cody?
So,
We can just reword
so
condition.
13 would be reworded to read what?
To reword that the maximum occupancy be 10 dry tent campsites and 10 dry RV, or 20. Is it
20 each.
Your
20
applicants-
20 dry tent sites and 20 RV sites, not to exceed a total of 40 for both.
So I move approval with
And
those.
is our number 9 then with the porta potty, is that gonna work for you with the 50?
Yeah, so that condition on number 10 is just saying that
I'd like to see a little give and take, so, when you get out there, and it's for your comfort as well, from your customers, when they're short of porta potties or it doesn't work out, people get really irritated in a hurry, so
She'll
So
figure that
we
out.
could-
a little push.
we could reword condition number 9 too, that just says that porta potties are provided to the primitive camping and dry RV sites, and then the 1 per 50 guests, that's a state requirement. So if she has 120 people camping out there, she would need 3.
Now, my last thing is then your maximum occupancy, it's beginning to look a little low, so, when you got 20 and 20.
Not really,
Wanna
not up to
adjust that.
200.
200?
Yes.
2020 is 40, that's 5 people a site, but they've got other people coming there. Oh, you're thinking, are most of the people going to stay that come there?
Yeah, it
See, I'm
won't
thinking
happen
the other
very
way, that you're going
often.
to have a certain amount of walk, drive in. you're assuming that the people that come there for the entertainment or whatever.
Charlie, they'll be reviewing it in
Okay,
6 months
then
too,
I don't
sir.
have a problem with the
Yeah,
200
yeah,
either.
yeah.
Okay,
Thank you for all your drill.
Yeah,
It's
no,
just
thank you.
okay.
little
All right.
hang-ups I get in my head.
I heard a motion over here
Yep, with the 2 changes.
with the 2 changes. Is there a second?
I'll second.
Motion and second. For approval of planned unit development 21-03 with 29 conditions, noting the change on 13
And 9.
and 9. Is there any further discussion? To confirm, does anyone else in the audience wish to speak on this issue? Seeing none, all those in favor signify by saying aye.
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 Those opposed, no. Motion carries.
Just a point, Rich, on number 11, staff is recommending to continue till March 22nd on that item.
Okay.
Did you see that? That's, people are probably in the audience today to speak on that, but do we ever contact the people that are speaking or want to speak? Do we tell them that we're continuing the item so they don't come and can come on the 22nd?
Yes, the neighbors were contacted, and then, however, since it was advertised, they do have the right to speak at the
Yes, they do.
meeting.
Yes, yes, they do. I
But
just
they
wondered
were-
if they knew. Thank you.
The ones who we had email addresses for were,
Okay,
Should've
I
been
just
notified.
didn't want them to show up and be mad because they weren't contacted, that it's a continuance on the issue, so, thank you.
Go ahead, Cody, number 11.
so item 11 is conditional use permit CU 21-04. It is to utilize existing living quarters above a garage to allow for bed and breakfast on the subject property in limited agriculture district. The applicant is Cole and Renee Foster. The property is zoned limited agriculture district, which requires a 10-acre lot size. The property is currently 10 acres. Criteria for approving conditional uses. Bed and breakfast take place entirely within a detached structure and should not be detrimental or endanger public health, safety, or general welfare of the public. Bed and breakfasts are considered a residential use, therefore the conditional use permit should not change the residential use of the property and thus should not have any long-term negative effects on the use and enjoyment of other properties in the immediate vicinity. Number 3, allowing this conditional use permit should not affect the normal orderly development or the improvement of any surrounding vacant property in the area. Number 4, the subject property is served by a private on-site wastewater treatment system and water is provided by the Pine Grove Water Association. Access to the property is off of an easement off of Stone Ridge Road. Number 5, access to the property will be provided via Stone Ridge Road. Stone Ridge Road is a private access easement that provides access to 8 properties and 6 residences. The bed and breakfast takes access off a shared easement with the neighboring property to the west. Number 6, the current zoning is limited agriculture districts. Bed and breakfasts are allowed in the district with a conditional use permit. The lot size is 10 acres, which is required for the limited agriculture district. And number 7, the future land use of the property is agriculture district, which allows us single-family residences as a primary use. Bed and breakfast is an accessory use, which is allowed through a conditional use permit. Property history, there was a violation on the property for operating a rental without a conditional use permit. No building permit for the living space above the garage and an undersized septic. For the building permit, the applicant has applied for a building permit. It is pending approval, approval of the conditional use permit. The septic, the applicant did submit a new on-site wastewater treatment system application, and our environmental planner has gone out and inspected that. Therefore, septic is no longer a violation. And if the conditional use permit is approved, it would allow for bed and breakfast on the property, and therefore the violation would end. Access to the property begins off Stone Ridge Road, and there is no special hazard area on the property. This was routed around for interdepartmental review. The only major concern back came from emergency services, just to make sure that the garage that houses the bed and breakfast is assigned its own address and that those addresses are posted at the end of the driveway. For the analysis, during the review process, it was discovered that the applicant did not have all the submittal requirements for the bed and breakfast. The South Dakota Department of Environmental and Natural Resources approval letter was not provided. The applicant has been in contact with DENR, and Matt Cherney from DENR has contacted staff that he is working on that approval letter. The South Dakota Department of Health lodging license for bed and breakfast. The applicant has submitted a copy of the lodging license, and discussing with him last week, the Department of Health is actually going out today to inspect the property for the lodging license and the sales tax license. The applicant and staff believe that since VRBO and Airbnb handle taxes, that sales tax license was not required. Staff did some research and contacted Department of Revenue, and granted, while Airbnb does handle the taxes and taxes have been filed for the property, he still is required to get a sales tax license because the Department of Revenue views it as a business, even though the county views it as a residential use. So therefore, staff is recommending to continue CU 21-04 to March 22nd, 2021 Planning Commission meeting for the applicant to submit his lodging license, the South Dakota approval letter for on-site wastewater treatment system, and the sales tax license to the planning department. If the applicant fails to submit these items by the continuation date, the conditional use permit application will be denied.
Thank you. Are there any questions for staff on this item? Okay. We do have 4 speaker request forms on this item. Noting that,
Mr. Chairman?
go ahead, Charlie.
Just for point of order here, we should put the motion to continue on the floor second for the discussion, so it's official to the record, because people aren't supposed to come from outside the meeting.
Prior to,
They have a right to come up and address the motion, is what they're doing. There should be a motion on the floor.
And I just want to state to the applicants in the audience if there's any questions for him as well.
Yeah, for people to respond, there should be a motion on the floor. Otherwise, the conversation should be limited to us, and I don't think that's what we want. That's just a point of order. We can waive that, certainly.
just trying to think of how that's been applied in the past.
I think you can do both, Charlie, because if you don't have, actually, I think it's the opposite. I think once you do a continuance, there should be no discussion.
Oh, I wasn't going to vote on it. I'm just saying that's their discussion of our motion.
Okay. I think you could do it either way.
Correct, but
Depends on what the chair wants to do.
Sure.
yes.
I think for the purposes of moving forward here, I'd like to hear the people on their speaker request forms if they wish to speak today, noting that it's likely going to be continued. First speaker request form I have is for Patrick, and I hope I have this right, Bryce Meister. Sir, if you would please state your name for the record when you come up.
My name is Pat Breezemeister, and I'm going to hold my comments per what Charlie there said, that till the 22nd, till you guys are in a position to understand. But I would hope that you read all the emails and stuff that I sent you, and you understand where the residents are coming from. Because what I didn't see in the staff report is what the residents feel about the issue. The only thing I saw that you guys would deny the request is if the applicant didn't have all your forms in. That seem logical?
No, usually
That
if you admit letters, they always give us the letters. So we have your letters.
That's awesome. But why isn't it in the staff report? That's a public document. Why doesn't it say?
They can be furnished to you, Patrick.
Well, I know they can be furnished, and I would appreciate it.
Yeah, let's hold tight here for a second. We've been given a few letters that didn't get to the staff in time. Otherwise, all of the documentation that's been given to staff should be in this report. And you're saying that there are letters from the landowners that are not in the report?
I don't know that. I know that 3 have responded. A 4th was gonna say something here, but she'll wait until the 22nd as well. We haven't heard from the 3 on rodeo. I would appreciate any kind of feedback that when we do, so I understand. But the rest of the comments, I'm gonna hold off. I just hope that you read the emails that I have sent, so you're prepared to
I've read the
Snow
emails.
or
I
someone.
can't speak for these folks, but staff sends out notifications. I did notice there was some discussion in there about the distance and some of those things, but we follow the same standard each time that we do that. And so if there's additional letters that you're aware of from your neighbors that haven't made it to staff that aren't in the staff report,
Well, let me ask you this. I know, this is kind of the exception committee. You guys are concerned about health and safety and water. I guess I'm gonna ask why you're using canned statements from the emergency services to say that you're just gonna put it. Somebody needs to go there besides the environmental safety guy, who is absolutely dynamite guy, but to go there and look at the property and look at my easement, which is a one-lane road, and see where the prevailing winds are coming from. What you're claiming here by your canned statement, which says should not endanger, not will not, and on the 22nd, I will ask you why it doesn't say will not, because I'm sure that gentleman down there will say, well, we can't insure, so we got to use the word should instead of will. And that tells me that you can't insure my safety. You can't insure what goes on. This is a one lane. The intent was not to have somebody constantly come in. The staff report didn't call the water commission. You guys talk about water up the wazoo. How sacred is water to us? We live in a frickin' high plains desert. But yet you're willing to agree to somebody to allow them to take showers for an hour, but yet you didn't contact the Water Association to find out whether or not they even remotely care. Well, if you look, they wrote a letter July 3rd that say, all 135 of us, please conserve water. You guys don't, it's nowhere in the documents does it say I did that.
Well, sir, if you look at water and you have someone part-time there, 6 times a year instead of someone there all year renting that residence, which legal he can do, that's less water.
No. They live there, and they're asking to have up to 6 people there daily. And per your requirement, you may allow 12 during the day or something like that. They all could take showers. They all could utilize water. They pay their $100 a day. They could utilize water, and I have to supplement it. My 2021 water bill went up.
So if you have
Because
6
they're
more
not,
people
I'm
that
sorry.
come visit you, or 6 more people that come visit other people, do everybody regulate that on each one of those houses or those residences? Do they check to see if they have?
You're missing my point.
Well, I'm
My
saying if it's a
point is,
rental, what's
I
the
have no
difference?
problem occasionally allowing people to have guests, family, whatever. That's what we live by.
Right.
But to have renters there that you can't insure, you don't know who those people are. There is nothing that you can say, do, write, promote, anything.
But you can't do that with other family members or other people visiting other
I'll
people
take
either.
that risk.
Right.
But I won't take the risk of a renter who can make a mistake, do whatever the hell they want, and all of a sudden, who's at risk? Oh, the guy with the prevailing winds. If there's a fire, how do the people get out if there's a fire on my property? Because somebody made a mistake. They're all good, wonderful renters. Oh, I'm going to ensure that they're just upstanding people. Really? We can say that? I don't think so.
But I'm going to be up straight. That goes both ways on everything you're talking about, whether the people out there or this property. Any of that could be the same as what, you can
But
turn
you're
that around.
increasing my risk. Each and every day, you're increasing my risk.
There's a lot of things, sir, that would increase your risk, not just this.
No.
I'm not saying I'm in agreement with this. I'm saying what you're saying, ask yourself if any of the other neighbors by you or in that area could do the same thing that you're asking this board to shut down somebody for, including yourself, if you had 6 other people visiting
You're
or you had
using the
other people.
excuse that I have that right. My privacy and peace and quiet is more important than the right to allow somebody else to upset that right. You're giving that applicant more rights than I have.
And
And you
remember
can say,
this,
well, I can apply to and all that kind of stuff. That's not the intent of the neighborhood.
and this is a use on review, so if those things are happening and there's complaints made based on factual information, sir, you actually can come back and say those things and you could prove it.
So it's up to me then to be the complainer. I have to be the watchdog because I will call the sheriff each and every day. And I will say, that line right there, they crossed that line on my property, that's trespassing. And I'm gonna drive that sheriff right up the wall and he's gonna come back to you and say, what are you doing? This guy has every right to call the sheriff each and every day and let them know about trespassing rights.
And if he's doing the right thing and everything turns out right, that'll be good too, because we don't know that until we make a
You
decision.
hit the point on the head.
I have
Who
renters,
don't know?
yes, but I have renters next door to me and they have
Who
rights
don't
too.
know? Not on a single lane easement. The next question that I'd like you guys to research, and I am talking too much, is please look the last time that you approved a CUP for a one-lane easement.
Mr. Chairman, can I ask?
Go
Patrick
ahead.
a que- Patrick, did you provide the original easements to these properties, or do you know
No,
who did,
unfortunately,
or
they're from 1983 and
it's been
1990.
there
So
since 1980?
there isn't anybody here that lives on the 8 properties or 8 tax codes and the 6 residents. All the original members are gone.
Okay, and I wanted to let you know, so you know again about paperwork, we were provided copies of that original easement. It's in your write-up. Thank you.
Okay. And just, I would hope that you could put yourself in the resident's shoes as well. I understand the applicant's point of view, but you got to look at the residents as well and the dangers and the risks by allowing that to occur to everybody else. And I know I listened to all of you and you're all concerned about citizen safety and health and emergency services getting there. And I will guarantee you, just by putting an address there, they're not going to find it. I have many examples. Notice who's first on the road? So on the 22nd, I'll get into more of that, but I do explain that into the email. So, common sense, please. That's what I'm asking for. And the right to have my own privacy and my own peace and quiet. Worked all my life for that. I chose to live at this spot. I wasn't born and raised here. You guys, if you don't know the special place that's here called the Black Hills, you have one special place here.
I'm not against it, sir, I'm just saying, even with, we're from a family of 11 kids. All 11 of us would have lived in there and had more people than what these people are having, so you're okay if it's rented to people that, live there, but you're not okay if it's rented out as a bed and breakfast, is that what you're trying to say? So if someone had 11
No, you're
11
putting words
kids,
into my mouth.
no, but
I'm concerned
sir, I'm
that,
just saying the same thing. If that can be a rental, if these people moved out and they had 11 kids with mom and dad, that would be more on that property. You're okay with them renting it to somebody, but
no,
not bed and
no, I'm
breakfast.
not. I'm not okay with renting it or anything like that. We are homeowners.
Okay,
I don't want it rented. I don't want it anything other than the peaceful tranquility of the people that reside in that neighborhood to enjoy what we have here. And it's very special. Not everybody in this country gets to enjoy what we have in this,
but you don't own
area.
their property, so they can rent it or they could sell it to whoever they wanted. So they could still sell it to someone with lots of kids or whatever, and they're legally, you couldn't do anything about it, Mr. Brightmeister. It's not always gonna be 1 or 2 people in the residences because you want it, it's property rights for that
Your
person too.
point is acceptable.
You see what I'm
I
saying?
understand your point.
Okay.
But
I'm
I
not,
hope you
I'm not trying to be
understand.
rude, I'm just trying to have you see
Same
the
way.
other side
I
of the
understand
story.
that. I'm just hoping that you have, upon reading and understanding where the citizens are coming from, that you please take that into account. That's all I ask. You guys can bend rules to do what's right. I know, that you're supposed to, that people use, ordinances to follow and state laws, but you all talked about it here in the prior issues that you had to go through. that you do have the power to do what's right and not just follow a staff report that's, I'll get into that on the 22nd.
Thank you.
Thank you, sir, for your comments. Next speaker request form is Jared Nooney. Is that right?
Yes, sir. Good morning, Commissioners. My name is Jared Nooney. I'm an attorney with Nooney & Soleil LLP in Rapid City, South Dakota. Given that this will be continued until March 22nd, I will just hold my comments to that point.
Okay, thank you very much. Next speaker request form is for Lowell Kolb.
I am Lowell Kolb. I'm willing to withhold my comments till the continuance if that makes things go better.
Okay. Thank you, sir. Last speaker request form is, I believe, the applicant, Cole Foster.
Good morning. I'll probably hold my comments too.
Okay.
I'll give you guys.
Yeah. Yep. I think that's fine.
Okay. One thing I would like to point out
Go
too,
ahead.
the easement keeps getting brought up. I did supply you with comments where it was voted. It was annexed into the road district.
Okay.
So.
And is that just, Cody, is that one of these letters that we received today?
Yeah.
Is that right?
Yeah. That one.
This one?
Right there. Yes.
Yep. Okay. Thank you.
It's set as a 20-foot wide road, so.
Okay.
Okay.
How wide is the road?
20. It was supposed to be. Yeah. Which would be 2 lanes, so.
It's supposed to be a 20-foot road, but it's only a, what right now?
At some spaces you can meet people, no problem. Closer to his house, it's tight because the fence is right up against the road.
Is the easement 20 foot or is it?
It was for a 20-foot road.
But it's only a 16, 14?
In some spots, yeah, without moving a fence. So it's supposed to be 20 foot.
So it might be a suggestion, just food for thought, if you're going to add more people on the road and there's an easement, you might have to widen that road a little bit if you're going to make it into somewhat of a business for safety as well, so. Okay, just food for thought, sir.
Thank you. That ends the speaker request forms. Are there any other folks in the audience that wish to speak on this item?
Documents of the easement.
If you could get to the microphone.
Oh, sorry, Pat
yeah.
Briesmeister again. The documents for the easement state that the homeowners have to vote on the annex of the Knotty Pine Road District, which basically states that all the current homeowners have to sign off on that. Well, only 2 homeowners have done that. So I can guarantee you that if the issue that he's riding on is that it got annexed in there, while it's true, we do use them for helping us with the gravel because our tax money, tried to do everybody a favor, the tax money went there for that specific purpose. But by vote, the 6 members that live there, the majority will take that out of the Knotty Pine Road District, and we'll go back to the existing HOA that you have a copy of, I hope, which is no problem. So whatever letter you have, that's great, but just please take into account there's always a point and a counterpoint to that. So I'm more than happy to take it out of the road district, and we'll go back to just doing what it was, and it was a very unimproved 1-lane easement prior to us moving out there.
So does Knotty Pine own the easement?
No, Patrick Briesmeister and Linda Briesmeister own the easement.
Okay, but you gave that easement for people to use it.
The easement allows the six residents that are basically south of that Knotty Pine 90-degree angle there have the right to use that easement. Yes.
And he's part of that easement?
I'm sorry?
And his house is
Absolutely,
part of that
he's
easement?
part of that easement.
Okay.
Yes.
So legally, do you have to, sorry to move this
Go
forward,
ahead.
but legally, does he have to do you have to give him that right because it wasn't the original intent or anything? I guess what I'm trying to say is what was.
He has the right for ingress and egress purposes to his property.
Okay,
That's how
that's
it's
what I need.
stated.
Thank you, sir.
The document we have is the minutes to the May 15th, 2018 Knotty Pine Road District meeting where they approved the annexation.
And they had to do that simply because I was told they were out of compliance. The Knotty Pine Road District needed to ask us to include our road and Rodeo Road, otherwise they were out of compliance. So that's what I was told. There was no, the annexing doesn't mean that it has anything to do other than our taxes are shared for the proper, grading, because I'll tell you, it was in bad shape prior to us moving out here, so.
Well, you might get extra income through that too, because
Don't
maybe
need the
he
income,
has
ma'am.
to improve that road before, maybe that's part of the stipulation, sir, is to make
I
that
don't
road
need the
wide enough.
extra income. I would rather have my peace and quiet.
Okay, but there might be some
To improve the
solutions,
road,
sir.
if he wants to make it 20 feet all over the place, have at her. It'll cost him more money than his house is worth to do that for the 0.6 of a mile it
There's
is.
got to be solutions for people in order to live by you. And if you'd want us to do that to him, we'd probably have to do it to you if you decided to improve or do anything. So remember, what you're asking somebody else to do, you should be able to do yourself as well, right?
Not asking to improve it. I wouldn't improve it.
Okay, I'm just saying in general, sir.
Thank you.
Thank you.
Further questions, comments?
Mr. Chairman.
Go
Can
ahead.
I ask Colin to come up? I'm pretty sure I know the direction, but I think it's important to the discussion we're having here. One, a road district is a separate government entity that we have no power over or discretionary authority over whatsoever. However, in the case of the road access agreement, all platted lots to be buildable must have an access. Is that correct? I believe under our
subdivision
sub,
regulation?
yeah, they have to have a legal access, or we can't put a building permit on them. So as I see it, we can honor the road, where I'm going with this, so that you know, and then you can either go to your drawing board and decide whether I'm right or wrong, whatever. But the way I see it is, the road district is of little concern to us, their actions. They have their own government authority to do as they see fit. But however, we can look at the access agreement as a document that's in regards to this request.
The commission can look at any data that's
Sure.
available to it that's relevant to make a decision. If the road district didn't exist and they didn't have it annexed and there was just an easement that said he's got ingress and egress, I think that would be relevant
You
for you
might not
to.
know, but it's got the word covenant in it. But I'm saying in this case, it's still an access agreement to the property. The word covenant was written out. Whoever drafted this particular one, it does have the word covenant in it. And we've been instructed we don't honor covenants. But I believe we should honor a road access agreement to a buildable site is what I'm saying.
Well, if it's an easement, then
And it's
I
a
think
good
that's
one.
what would control the covenants. The county doesn't enforce covenants at all,
Right.
like you've said. So those are completely irrelevant.
I'm saying there isn't the word covenant's in it. You probably didn't have a chance to
Covenant's an
read it.
old legal word that goes back to, archaic usage in the 1300s that has somehow
Refers to
made it forward.
covenants, but it's really an easement, an access
Covenant just
easement.
means, agreement.
Okay. I just wanted to make sure that we were all on the same page, and then the people heard where I'm coming from, because I'm going to be talking about the same thing when we bring this up again.
Further questions? Anyone else in the audience wish to speak on this item? Seeing none, staff recommends to continue conditional use permit CU 21-04 to the March 22nd, 2021 Planning Commission meeting. Is there a motion?
I would move that to continue.
Second. Motion and second to continue conditional use permit 21-04 to the March 22nd, 2021 meeting. Further discussion?
Is it going to be per the staff's recommendation? Because it says if the paperwork isn't here, it's going to be denied? Or was that in your?
I don't know the answer to that because we'll have to, based on what information may or may not come available until then.
I don't believe you have to put that in there. That's just staff will recommend
I'm just saying
denial
right now it is.
if we don't have that.
Okay.
Further discussion? Hearing none, seeing none. All those in favor signify by saying aye.
Aye.
Those opposed, no. Motion carries. Item 12, the county board report.
The county board, the Board of Commissioners concurred with the Planning Commission's recommendations from the February 8th, 2021 Planning Commission meeting.
Items from the public. Does anyone in the audience wish to speak on anything further? Looks like we're exiting.
Being public?
Items 14, items from the staff.
I guess I just have one quick update. We're doing our first round of interviews for a position in the office, the Assistant Environmental Planner, on Thursday. So hopefully we will be able to. How many applicants did you have? 21, I believe.
Wow.
So
Wow.
we're interviewing 5 or 6. So
When we talked last summer, you said there would be a building inspector position added this year. Is that still?
yes, we actually that advertisement just closed this weekend. So we're going through those applications. And so those interviews will possibly end of next week.
Okay. Items from the membership.
I don't mean to make a long meeting longer.
Have Charlie and Deb at the same
Yeah.
meeting.
That's correct.
Is that a motion?
They're going to vote that through. But I went and got organized, so I won't make it very long. We've got to look at the future of this code violators. It's a problem. We never used to have every meeting people come in that were already doing things and we had to go catch them. This is getting ridiculous without some sort of penalty besides a financial one. There should be some moratorium put on them when they do it. And yes, I'll go through the things I think you got to do.
Charlie, I'll just answer your question. It happens through the city, let alone the county, so you're not going to cure that issue. It's just what people do and then ask for forgiveness.
Yeah, but our voters think we're idiots sometimes because we look the other way. They went ahead and did it. I have a lot of people up in Hill City that jump up my backside about saying, well, the clown was already doing it. And I mean, they get really verbal about it. And you went ahead and just shook your head and said, oh, it's okay. You were a nice guy. So now we'll vote it through and rule. That way we limit the violation. Well, they, on the other hand, don't understand that perhaps it wasn't that person, it was somebody else that built it. There's others, extenuating circumstances sometimes, but when there's not, I think there ought to be some penalty. So, I mean, that's where I'm coming from, and so do our voters. So do these people out here that pay taxes. They wonder what we're doing. And there's a lot of people know how vocal I am, so they're on the phone to me. So, and the ones that don't like me either.
What else you got, Charlie?
Anyway, that's it.
Keep
But
going, Charlie.
we've got to look at that, and I had it down here, Colin. I had it down for you to give us some idea what we can do in the future. Besides, he was unhappy about the $400 or $300 or whatever. I'm going, wait a minute, were you sleeping? So that's where I'm coming from. Enough said. It's been a long meeting.
Mr. Chair, if I may.
Go ahead, Colin.
I'll be quick. So each violation is punishable by 30 days in the county jail. That'll never happen. A $500 fine, probably not going to happen, or both. And because we're more worried about bringing property into compliance for the safety, health, and general welfare, we really focus on getting those addressed. I know that it's a concern for this commission and the county commission, and it's frustrating. Also frustrating with that is that with COVID, we haven't been able to move forward really with any of the cases because oftentimes people bring their property into compliance with Dwayne Dwayne works with them. If they don't bring it into compliance with Dwayne, then it comes to me and I get involved, and then we start a court case. Usually before that, they resolve the issue. But for those people that don't, we haven't been able to do anything for roughly about a year now. So I know it's frustrating. There's not a whole lot. If there's something that's immediate and dangerous, we can seek an injunction. So if there's a really bad water issue, something at Mount Rushmore, some kind of hotel, there were some water issues. We went to court and got an injunction with that a few years ago. So when it's immediate health, safety, and general welfare, we'll go and we'll get a civil injunction. Another example would be if there was something in the floodplain and there was a lot of water coming, and we knew that it was going to be a flooding hazard issue. So that's all I got now.
It's just getting to the point, though, that the people that talk to me say, the old statement that they'd rather ask forgiveness than ask for approval. And that's ridiculous. If we already know in advance that these things are going on, there has to be some way to at least slap somebody's hand and say, now back your butt up and let's get it together. Well, we want you to have this
Charlie, go ahead and
point.
give him that 500 fine and that 30 days in jail. I won't be here that day, hopefully.
No. I'm suggesting,
finally
that I think there should be a delay when somebody's run one of these things like a bed and breakfast or 6 months before you can take off again. And that should be one of the conditions that comes right out of here.
Anytime, Charlie. You bring that forward.
And that's the way I feel, because these people race these things through. Ask her to go faster. Ask the people to go faster. Get it done for me.
True.
I don't care whether I was in violation. I need it quickly now to work the season.
I'm listening to you, and people think it's political. It's not political.
Anyway, I'm not
of
of that belief, and I'm not, and I don't believe that the people should get penalized. In other words, we've got to have some give or take here. If you got the property, bought the property later, and you had, and most people turn over a file and they thought they were doing the right thing, we've got to give some consideration. But for people that blatantly do it, and I've got them on the phone to me, I mean, we've got enough renegades around here without saying let's have free run of the thing.
Renegades.
Okay. Yes, I said that.
Does anyone else have anything for the membership? I'm sorry, Colin.
Speak for 20 minutes.
Thank you, Colin.
Well, I was going to say that the fines double, and then the person can come before the county commission and they can ask for forgiveness and ask for those fees to get waived.
Control the fines.
Right.
We don't decide who gets the
A lot of times I keep the fines myself unless it's a shed or something, because people do not, people don't know that they can't build a shed or something. It's like a shed is different than you got to build a
Make them
building
pay
permit.
extra to the wheel tax.
I'm not paying $500 fine for a shed for somebody costing probably $500.
All right.
Well, the fines are by operation of ordinance, and then as far as people not knowing what they're supposed to do and claiming ignorance, there's so many different ways to articulate how ridiculous that is, because it goes back to Roman times. Deb has heard me say this many a time, that you are charged with knowing what the law is and knowing all parts of it. It doesn't matter whether you have a law degree or you don't. If you want to do something, you have to know what you're going to do. You have to know the law.
So we're getting
So knowing the law covenant, or Mr. Lawyer guy, so can we?
His name's Colin.
I know, I like Colin. I just give him crap all the time. So we can bond surety for the second access this time and have an affidavit, right?
I think talking about any specific cases would be inappropriate.
Yeah, I would not comment on previous
I'm not saying,
items on the agenda.
I'm not saying certain cases, I'm saying in general.
In
Because
general,
you can do that
bonding-
water, sewer, different stuff or not.
For infrastructure improvements, bonding can be a requirement.
Okay.
That's allowed in our ordinances, and I believe that's one thing that Brittany's.
That's my
communicated-
question, not a certain issue.
That we're gonna get back to, because over the past like 5, or Jerry might be able to speak to this too, we've gotten away from the bonding requirements. And then if people don't follow through, it's, well, like, what are we gonna do?
Too bad.
It's kind of tough to come and enforce something like
I
that.
also noticed on the bonding requirements, it's up to 2 years. Well, most people aren't going to go do those improvements until, they sell it as a subdivision. So then after 2 years, it's already gone. So remember, when you're setting certain years on stuff, it should be something different when you're looking at that, Collins. Cullen, because then in 2 years, like I said, a lot of times it's not happening for 4 to 5 years before that second improvement's gonna be done, or it's gonna be subdivided or whatever. It should be put it as once it's subdivided, it should be still back on the bond should still be in place. It shouldn't be taken off in 2 years. Does that make sense?
Yeah, and I
However you
think
do
one of the
that.
complicating factors with that is when somebody plats something, they don't necessarily have to build.
Yeah.
Right.
So they could wait 20 years, sell it, and then that person could build.
But I'm
So-
saying, once it's subdivided, you could put that on there back on the applicant that's selling it.
Yes, there's a way to do anything you want, really. So.
But just something for future thought, because then a lot of times they've sold it to somebody else and that's gone.
Mr. Chairman, we're getting more and more pressure from out-of-state people that consider us a free state. And we need to think about more of these things when we're doing it, that you're talking about. These people think they're coming to a state with the same set of rules. It's easy to get a driveway. We're going to hook up to water and sewer, and life's going to be beautiful. And that's not the case here. We're a much more rural, spread out state than they think. They don't even understand snow control. Some of them have driveways that they couldn't get down if they didn't have a truck.
Well, us city folk don't know a lot about septic and all that stuff either, so it's not just from out of state.
Believe me, I do. And they live up there and tell me about it all the time.
I believe that.
Thank you.
Are there further items from the membership? Otherwise,
You can speak if you like it.
I was hoping being quiet would give some kind of message.
I was thinking you were thinking that.
He's a city guy, basically.
I do have to agree with Charlie's position on these penalties. I think there needs to be some kind of, even if it's a modest thing.
Yes.
I mean, you don't want to build contempt for government, and you do it by allowing people to abuse it, which is what that is really. So anyway, but that's all I'm going to say about it.
Jerry, will these 2 pages be in our next packet?
Yes.
Okay.
Did anybody see the easement? I didn't see the paper for the easement.
It's yeah.
It's in there.
Well, it's this other page here that was in next to that,
It doesn't, you can have a copy. It doesn't have the easement.
no, it was,
I got that.
oh, the drawing on the map.
Is there? Is there a document about the
Read
easement
that road
in the
easement.
packet?
Read
think
the
so.
road. These
Probably
people have a
gonna need
lot of leeway.
For the next meeting.
I just want to step in because it sounds like we might be.
let's
talking
not talk
something.
about previous items.
So,
Okay, stop.
Thank you, Colin. I hope you didn't take that personal about the attorneys.
You should.
But you're on the dole too, from here, so.
My husband's an attorney too, so.
That's right. That's why they love me.
Here you go, Charlie. You offended at least 10 people in the room out of 12.
We're,
Sorry, Mr. Chair.
I do want to move on to item 16. So I'm confirming there's no more items here, correct? Item 16, adjournment. Is there a motion?
I move we adjourn.
Second.
Motion and second. Further discussion? All those in favor signify by saying aye.
Aye.
Those opposed, no. Motion carries. We're adjourned.
Thanks for the leeway, Mr.